10,000, 20,000 per case. But you have to make a choice. That it must be a choice of yours, because they will cancel who do not give it their best shot. It must be from within you, like it was said earlier, to say, will I sit down and give this accused person my best shot? Will I do my research? Will I prepare? Or is it because the judge is going to give me 10,000 shillings at the end of the day, I'll just go and... So for me, it is that which really got me introduced to this litigation. The fact of seeing these poor people, they have been abandoned, they have been on remand for 10 years, the judge has come, when he had a chance, he's going to be there another 3 years. So what are the challenges for you? The challenges for you is to be consistent and not lose, not become disappointed. Because remember, you are challenging bad governance. You are challenging power. So the people you are challenging are not going to sit back and say, okay, fine, we give you this. They will fight back. So you have to be consistent, courageous, and focused on what you want. There is this case of Rubaramira Duranga versus Attorney General. It was a constitutional petition. Somewhere in 2005, we were going for these local elections, but we had not, the elections we were going for were not assuring freedom of association, freedom of speech. So, the Constitutional Court declared those provisions unconstitutional and stopped the elections of those officials. If you look at LC1 officials, there were over 10,000 offices. But what did the government do? To just ignore the Constitutional Court. Those people stayed in office illegally for 5 years. Don't be disappointed because that has happened. That because you expected that the law will be followed. Now the government has refused to, has ignored you. Don't be. Push on. Somebody will build on what you are doing, even if you don't achieve it. So what kind of rule of law is that? When the government, which is supposed to guarantee rule of law, is itself breaking the law and ignoring the Constitutional Court. These are the things you must bring out if you want a stable society. You can think that you are stable when a very small thing will blow away everything for you if you do not speak up, if you do not litigate for these principles. Then there is the Kasozi and other versus Attorney General. Consolidated. This decision the judgment was given in 2015, and it was addressing Captain Peter. This was addressing the elections of army representatives to Parliament, the procedure, the election of the youth to Parliament, the election of other interest groups to Parliament. And they nullified the law under which those were being elected. But the government just went on as if everything is normal. The danger with that is that it is a slow slide into anarchy. It looks small, but whenever you don't respect the rule of law, you are simply going down a gradient you're going to arrive there. And it's the interest of us lawyers that we have a stable society. Because when things collapse, everybody runs away. For us who have seen these things, for none of you are young, but people like Professor Sempebwa, people like Captain Vitato, they are. We've been in a practice and we have seen what happens when you have to begin afresh, when everything is going completely gone. It is in your interest, as I said earlier, that you are involved in this public interest litigation in order to uphold the rule of law. And that's how you will be safe. That's how your practice will be safe. After 1986, most of us lawyers just began afresh. Things had been destroyed, the files had been looted, things were gone and so on. Same thing in 79 and so on. So we have not had that for quite some time. But it doesn't mean that it may not happen. There is this case of Mwanga Kivumbi. 2006, on assembly and speech and the role of the police. It is clear. What did the government do? Wanted to circumvent that, go around and come up with the Public Order Management Act. To repeat the same things the court had said it will not be done. Fortunately, that has also been thrown outside now. It is a consistent fight. Even when it did that, public interest litigation still went back, and still it has happened again. It is pushing the bad people in a corner, and that is good for freedoms. That is good for democracy. That's good for the rule of law. The last challenge I want to speak about is time in our courts. You may get disappointed that you file and something is not being determined. I filed a case in 2007. James Mwanda versus Moses Mwanda versus Atoneche. It had what people call sensitive materials therein. So somebody just sat on it. Whenever I would go to the registry, the file was not there. So one time I went to the registrar and said, when I register, I don't understand what is happening to this case. The registrar called in the head of the clerks, castigated her, said, you must forget this file. So I went to the head of the clerk, I'll come back after 1 week to give you time to get this file. When I went back after the week, what does the clerk tells me? Counsel, you are crucifying us for nothing. That file is in the registrar's office. Because it had sensitive things which would touch on individuals. From 2007, it wasn't fixed. So in 2015, I wrote an article in Monitor, the Monitor newspaper, titled, "Did the Constituent Assembly are in creating the Constitutional Court?" In which I said, I filed a case in 2007, it has never been court listed. Another one, National Resistance Movement versus Sechikubo, was filed in 2013. The court ordered us to file affidavits in counter affidavits on Saturday and Sunday. The matter was heard on a daily basis. And the judgment delivered within that same year. So in the Monitor newspaper, I asked a question. I said, what do I tell Moses Mwanda? Because Moses Mwanda will see me as favoring Sechiku. How come Sechiku's case of 2013, you have finished it, but mine of 2007, you have never done it? But they are good people. They are good people in that judiciary. Justice Remy Kasule called me in his chambers. He was at the time was the judge of the Supreme Court. Of the court of, he was the justice of the court of appeal. He called me in his chambers after he read the article. Asked me about the whole thing and so on. I explained. He called in the registrar, told the registrar, it is not my work, but I'm concerned about this case. Then it was fixed. So the question of time of you getting disappointed because your case is taking too long will be there. Those are the challenges you'll meet. But remember always that your litigation can bring about political and social justice. Remember that now that we can now implement international instruments, conventions. Your field is wider. And indeed, this type of litigation has flourished in Uganda, despite the challenges and the problems I'm raising. On the other hand, it has flourished. We have had cases like Onyango, but I've listed several in my paper, which shows that this litigation is having some achievements. That you should not be disappointed, but just push ahead. Now the procedure, notice of motion in the Constitutional Court, the petition. But let me say something about the petitions in the Constitutional Court as you go there. You have seen of recent the court has been throwing out very many constitutional petitions. You should analyze the decisions of Attorney General versus Tinyemfuza David, Civil Appeal number 1 of 1997, and also another Supreme Court decision, Serugo versus Attorney General and Kampala City Council. To avoid your petition being summarily thrown out. The court is very strict that your petition must raise a question for constitutional interpretation. So very many constitutional petitions have been thrown out because the court has said there is nothing here to interpret. It is critical, this is very critical, that when you go to the Constitutional Court, ensure that you are asking the court to interpret an article in order to resolve the dispute you have. The way Wambuzi put it is the resolution of your claim dependent on the interpretation of the Constitution? If it is not, they will throw it. Let me just give you an example. Maybe somebody has been defamed. A client has been defamed, defamation, and you think it touches on a constitutional provision. Yes, it might violate a constitutional provision, but does it involve interpretation of the Constitution? Won't you be told, but counsel, why don't you go to the remedy in tort? Why don't you go and file in a tort? This is tortious. So for you in public interest litigation, be very careful about Article 137. But if by chance you ever reach the Supreme Court in one of them, challenge this decision of Tinyefunza and the Attorney General, because there is a powerful dissent by Mlenga and Sekoko. May their souls rest in eternity. They have a powerful defense. So it is possible that we might move away from this summary dismissal of constitutional petitions because of that. The future. I am hoping that the East African Law Society will look at a possibility of institutionalizing public interest litigation. I know Uganda Law Society has something similar. They can send you a case and you do it pro bono. I've done it several before from Uganda Law Society. But as it was said, there is the problem of finances for our lawyers. In order for us to push public interest litigation, we need to institutionalize it. We need to recognize that Ugandan lawyers should be supported in this issue. Yes, one might feel very, very passionate about public interest litigation, but one also has to eat food at home. Secondly, judicial restraint. There is a judicial restraint. Despite the good stories, there has also been a judicial restraint on the part of our courts. And I started to notice this after the Constitutional Court made a decision on the Referendum Act. I think nullified it or something. And the president was very unhappy. He said, what is all this? I thought these courts are just there to catch these cases of thieves and of chicken and so on. Can they also be determining matters of the destiny of the country? Then there were people who were organized to demonstrate against the courts. Then I started noticing some restraint on the part of the Constitutional Court especially. These are things you should take into account that they are there. But stay steadfast. In all of us, there is an element of doing good. To be human is to be good. It is there in you. It's just you to click on that part of the good and go into public interest litigation. Thank you for your kind attention.
Thank you so much, Honorable Wandera, for those insightful words. I think we've all learned a lot about the history and the future of public interest litigation in Uganda. Thank you so much, Honorable. So our next speaker is a founding partner at Chirunda and Wasike Advocates and a lecturer at Makerere University. He is a member of the Uganda Law Society, the East Africa Law Society, and the Uganda Christian Lawyers Fraternity. He has published in areas of human rights, constitutional law, intellectual property, land law, international environmental law, and international trade law. Personally, I'm proud to say that he was my lecturer while at Makerere University, and I found him to be one of the best lecturers because he would give the students so much time to ask so many questions and interact with them and generally be not only a lecturer, but also a friend to the students. Ladies and gentlemen, join me in welcoming our next speaker, Mr. Robert Chirunda.
Good morning, ladies and gentlemen. I am not very sure of the protocol in the room, so I am going to try and steer away from the complications that come from trying to be careful and just say what a privilege it is for me to speak this morning. Thank you very much, Naomi, for a very heartwarming introduction and very humbling as well. Also, let me say that it's a huge, high and enviable privilege to be sharing the rostrum today with some of the minds I admire very deeply and with whom I have had the highest and singular privilege of working side by side in public interest litigation. Senior Counsel Professor Sempebwa, my older brother, and in my view, the Senior Counsel, the affable Mr. Wandera Ogalo. I have learned very much from those baobab trees of public interest litigation, if I might use the expression. Therefore, I am going to try and say very little because of the collective wisdom of these distinguished colleagues. I wouldn't want to spoil the party. But I thought it was a very, and I came in while Mr. Gallo was speaking. We've done some cases together, and I am proud, sir. I like to acknowledge people publicly because I don't want to do it at your funeral. No. I'm very, very proud to say that in the cases that I have worked with Mr. Gallo and Professor Sempebwa, I have done more learning than I have in many years of reading the law. A meeting with them will change your life, and I will talk about that briefly. I'm going to try and keep this short. I was asked to speak about, what's the phrasing of the topic? Developing a litigation strategy from the problem to case development. So I'm going to try and speak really from my experience, not as illustrious as my older brothers, but the cases that I have handled, and maybe share a few experiences as briefly and quickly as I can. I have found that we usually skip a very simple question, which I would suggest to you should be the starting point for anyone going into public interest litigation. I'd like to add my voice to Mr. Gallo's caution. It is really our duty to engage in this stuff. I used to, when I left law school, when I left LDC, I considered myself traditionally a commercial practitioner. And I still spend most of my life there. I ended up in public interest litigation as a matter of necessity. And I think that we ignore these spaces that are on peril, risk, and chagrin. But now I return to where I was. The first question is, what is the actual problem you are seeking to address? Sometimes people come to us with cases, this one I want to file in public interest. But it's really a squabble between two commercial parties. And there's just no public interest question. Other times you have a very important case that is contextualized differently. I believe that litigation is storytelling. And we can all tell the same story differently and get different results. A story is told of an event that happened somewhere in Scotland. There was a huge gathering of people in the creative arts. And there were poets, there were actors, there were all sorts of people. About 20,000 people in the audience. So the night before this convention of creative artists took off, they decided to do poem recitals. And in this 20,000 seater audience, a gentleman stood up and came to the stage and recited a very famous piece of poetry, King David's Psalm 23, which I'm sure those who practice Christianity may be familiar with. The Lord is my shepherd, I shall not want. He makes me to lie down in green pastures, and so on and so forth. He used King James English. He maketh me to lie down in green pastures. He restoreth my soul. It was flawless. When he finished, every single person without exception stood up and gave him a standing ovation because of his gifted oratory skills. It was beautiful. As he left the stage and went to sit down, an old Irish lady walked to the pulpit. Nobody knew her. The previous person was a poet of repute. And in her frail voice, this old lady recited the exact same piece of poetry. The Lord is my shepherd, I shall not want. He makes me to lie down in green pastures. He leads me beside the still waters, and so on and so forth. When she finished, every single person in that room, without exception, was crying. Same piece of literature, two different orators, two different reactions. So as she walked off, the master of ceremonies walked to the rostrum and said, no, madam, would you please come back? When he finished, we all stood up and clapped. When you finished, we all cried. Can you explain to us the difference? And this old Irish lady in her frail voice said, that gentleman knows the psalm. I know the shepherd. She put the microphone down and walked away. Litigation is storytelling. You can have the best story. If you don't tell it well, you're done. I'll give you another example. I had the privilege of representing the Initiative for Socioeconomic Rights, a case that is very near and dear to me. It's very, very personal. It is one of the cases that suffered the fate that Mr. Okalo talked about earlier. I was out of the country when I got the phone call to say, we want you to represent us and a few clients in this matter. What was the issue? The issue was the lack of sign language interpreters at government hospitals. And they said, you know, deaf people suffer a lot when they go to hospital. I'll just pause for a second and recognize Senior Counsel, the President of the Law Society, President Bernardo Undo, and I believe also President of the East African Law Society. Not anymore. Well, past President of the ELS. Welcome, Mr. President. I said to these people, the kind and generous people at ISA who had called me, I said, you're pitching this the wrong way, because they had taken 15 minutes explaining to me how important this case is. You know, deaf people, when they go, they sit in lines for a very long time because when they call them, they can't hear. I said, you're pitching it the wrong way. They said, how should we do it? I said, walk into a courtroom and God help us, let there be a lady on that panel. Ask them this question: have you ever wondered how a pregnant and expecting mother who is deaf, when she gets to her, says, I think my baby is in breach? Anyone, ladies tell us, I have never given birth before. It stands to reason to assume. But ladies tell us that if you've given birth once, you probably know when something is wrong with an advanced pregnancy. How do these ladies explain? And everyone said, by the way, when we went into court that morning, I did something that I confess, now that the matter is over, was cheeky. I made an application. I said, my lords, I'd like to apply. I noticed around the court there is no sign language interpreter. This is a case about deaf people. I have deaf people in the court, stand up, stand up. They can't even follow their own proceedings. Surely it is their constitutional right to understand their case. The Honorable Mr. Justice Frederick Martin Stevens Egona Ntende was chairing the panel. I can never get over the look on his face. He had this interesting smile. And he said, but counsel, that is a serious matter, but couldn't you have written? I said, my lord, you are right, it is a serious matter, and perhaps it goes to the root of this petition. I felt that in that moment I had argued my case. I needed not argue it anymore. We had raised what I consider very interesting questions for interpretation. The court is not bothered. I personally take the unpopular view, and I will go ahead and risk saying this. I think that it is time to just shut down that court and move on. We should just stop wasting time pretending to be litigating constitutional matters. We shut it down, we move on. But that is my view, to which I bind only myself. And I have my long reasons for saying that. Because it is heartbreaking. I appeared with Mr. Gallo once, and let me, at the risk of injuring our friendship, tell on him. He was frustrated, and I could see it. Because he stood up and said, my lords, can I have at least 20 minutes to explain, to highlight a few things? No. We will read your conferencing notes. I could see my older brother really struggling. He said, what is the point of coming to these courts anymore if we won't even argue? And I miss the days when we went to those courts to argue. The first constitutional trial I attended, and since he's here, I'll tell the story. I have told it many, many times publicly, was Susan Chikula versus the Attorney General in 2005. It left a lasting impact on the lawyer that I am today, and I'll tell you why. We walked into court. I was just about to finish LDC at the time. It was a week to our LDC exams. And the court was full. It was the biggest constitutional case in a while. I think after the referendum cases and so on. And my God, it was the bench that you all dream about. The Honorable late Letitia Mukasa-Chikonyogo was presiding as DC chair, and you had the affable Mpajiwa Higeine, you had Twinomojuni Justice of Appeal, it was the panel to dream of. But on the bar you had the bar that I really miss. For the Attorney General you had now Justice Mike Chivita. If you never ever saw him in action, I warn you. He is as thorough in advocacy as he is a towering giant physically. Never, you would know better than to underestimate him. And he had maybe, I think, 2 or 3 colleagues with him. For the petitioners, you had Katende Sempebwa, and you had the senior counsel, J.W. Katende, you had senior counsel, Professor Sempebwa, you had Sim Katende. My God, it was the stuff you don't see on suits. What left so much that morning, and I could spend the day telling you about that case, but this is what blew me away. If I recall correctly, the case there were 5 grounds, I think. Senior Counsel John Katende stood up and argued, and I will never get, I still quote the name Justice Kittingar, the way that he said it in court that morning. It was moving, riveting, I might add. That was until Professor Sempebwa stood up. And he had a black copy of the Constitution. I recall this like it was yesterday. And he had a pen in the other hand, and he said, my lords, I am going to argue. I never imitate people in their presence. Professor, please forgive me. I am going to argue grounds 2 and 4. Should you find for the petitioner in ground 4, ground 5 is moot. Should you find against the petitioner in ground 4, then I will have to argue ground 5. My lords, if I may turn to ground 2, it is whether the death penalty amounts to a violation of the right to freedom from cruel, inhuman, and degrading treatment under Article 24. It states, he read from the Constitution, put the Constitution down, and stayed with his pen. And for 2 hours, Professor Sempe spoke from memory, did not turn a single page, quoted case, judgment, page. I quote. He would recite a paragraph. He would only pause to allow them to turn, because I think there were 4 volumes in 3 colors. There was a blue one, there was a yellow one, and I think a red one. And he would say, that is case number this in your blue folder, the second one. They would turn. Then he would say, I quote. I have never since, to this day, seen any advocate in this country argue a case like that. Professor, some of us, our admiration from you comes from moments like those. And I kid you not, I can give you friends who were there and they will tell you. I remember when he finished, the DCJ said, I think this is an appropriate time to take a break. We broke for lunch because he had given a thorough lecture on 2 grounds of the Constitution, 2 grounds of the petition, without turning a page, citing judgment, judge, page, and quoting South African jurisprudence, Canadian jurisprudence, Ugandan jurisprudence, and distinguishing them. I have tried to see if I could ever... All these 17 years later, I remember that day like it was yesterday. I remember Justice Chivita cross-examining Susan Chigula and asking, you have testified here, do the dead speak to you? It was the strangest question ever. But my point there is, litigation is storytelling. Sometimes we forget the simple basics. How do you sell your story? All of us have different styles. Senior counsel Katende sold his story very, very well. The first thing that impressed me was just his diction. It's amazing. I got to court today, and I'm sorry to say this, especially on camera, but sometimes the English that you hear in these courts is filling an adjective of your choice. Because I don't want to be regarded as insulting colleagues. But let's just say I think we can raise the bar. If you ever walked into a court and you listened to our senior colleague Peter Walubiri argue, you would be struck by the simplicity of his expression, the clarity of his arguments, and yet the gravitas. It is breathtaking. I would say that the starting point, now I've deviated from where I was, but let me go back to my notes. This is what happens when you have your idols in the room. You get a bit distracted. What is the actual problem? Crystallize the problem and then determine how you're going to solve it. Because I usually start with defining 2 things. What will be my cause of action and what is the remedy? We handled the matter again with Professor where our strategy was simple. We pick a remedy that is so scandalous, no court in its right mind would ever give it to us, and make it number 1. And then the actual remedy we want, we make it like number 3 or number 4. And I think Professor had played out the way we had anticipated. They rubbished us on the first one after a lot of politicking, adjourn this, adjourn that, this argument, that argument. They forced the AG to concede certain things. And then as a compromise position, really, they gave us remedies number 3 and number 4. So to the ordinary litigant, we probably lost that application. But to those of us who had been part of the strategy from the beginning, I think it would stand to reason to say we achieved our objective. Professor Sempe was my client. Can you imagine? And say no. So I would say define very clearly what is the problem, what is the solution. Now there is a big distinction between solutions and decisions, victories and losses. Sometimes as lawyers we get locked up in the thrill to win, and we forget that the win doesn't necessarily rest in the words, this petition succeeds. sometimes the win is the fact that you made the argument, I think. And so, Professor Mbazira, one of the, in my view, leading minds on public interest litigation, certainly one of the founding people in certain areas of it, we would not have structural interdicts in Ugandan jurisprudence without him. Said to me once, you know, the best way to go about it is an incremental approach. If you have a big problem, break it down into small cases and litigate them over time. After a particular election, people came to me and said, do you want to join the presidential petition? I declined, and I argued that at that time it was akin to a modest version of a fool's errand, and I don't like to run those. I had my reasons for that extreme position. But I advised on a different approach. I said, no, you conduct a court of public opinion. You go and appoint 12 people, sit them in a hall somewhere, and tell everyone who feels that they are aggrieved about the election to come and plead their case. Collect all the information, publish it. Document said, the state would never allow this to happen. I said, you try, then they block you, then you'll have made your point. You know, sometimes advocacy can start in what seems like a silly thing. Yesterday, Kampala had a very interesting development, which I think people underlooked. I think Robert Kabshenga is the one who caught the significance of it. A porthole exhibition. Not a single printed photograph, not a venue, zero cost. I think it doesn't cost too much to send out a tweet. But one journalist sat down and said, we're going to organize a porthole exhibition. I think it stands to reason to say he succeeded. Now, are there legal issues arising from that? I think so. But his approach was unconventional. In South Africa, there is a madman, I use the word mad here figuratively, who sued the Constitutional Court. And guess where he took his case? He sued the justice of the Constitutional Court and he took his case to the Constitutional Court. And at first they refused to hear him. Then eventually he kept fighting the same case, and they had him. I think the closest we came here was the Honorable John Ken Luchamuzi when he sued the Attorney General, and his cause of action was, the President has violated the Constitution in refusing to appoint justices of the Supreme Court. What was Luchamuzi's problem? He had been thrown out of Parliament for not filing a document, which is a requirement of the law. His solution, his petition had been lying there because a certain gentleman somewhere had taken his time to sign an instrument appointing justices to the Supreme Court. John Ken Luchamuzi's solution was file a petition to the Constitutional Court challenging this gentleman for really not signing a document. What was the outcome? They appointed justices of the Supreme Court and then dismissed his petition. Would you say he won or lost? Another one, less political, was Joyce Nakachwa versus the Attorney General. Philip Karugaba, our senior colleague, files this petition. While he's handling, midway, the petitioner dies. So they tell him, oh no, the petitioner bets the old abatement rule. And he appeals to the Supreme Court, says, forget it. What do you mean the petitioner bets? Just because the petitioner has died. As I recall, this was Justice Odoki's bench. What they did was they came back, reviewed the Constitutional Court rules, removed the abatement rule, then decided the appeal and said, yeah, this thing is overtaken. The rule doesn't exist anymore. So my point there is there's a huge difference between solutions and decisions, victories and losses. What are you focusing on? Not all solutions lie in winning the application or the petition. Of course, there is the serious critical question of when, where, and how to engage. That also ties to where I had deviated from on how do you tell your story. In some cases that we've handled, Professor Mbazira gave me a piece of advice that I took very seriously and has helped me to this day. if you're representing an NGO or a company limited by a guarantee, give your petition a human face. In the end, constitutional questions affect real. Give your petition a human face. You will be surprised how easily people relate to stories when they see a victim. I think we've gotten so lost in the political side of constitutionalism that we've lost the simple touch of humanity that is the basis of economic social rights. And if you want to understand what I mean, you ask yourself why, when a certain gentleman has a birthday, last weekend, people gathered to just run around. Now, the cancer cause is powerful, so is fistula. But if I called for a cancer run, I am not too sure that I would get 20 people. If this gentleman called for a run on anything, if he said, let's run because the East Africa Law Society logo is blue, I think it is safe to say he might get at least 2,000. What does that tell you? The significance of putting identity to a case, to a cause, I think should not be underestimated. There's the question of who is your audience. Many times we forget that when we walk into a courtroom, the audience is not just the judge. Sometimes we get carried away, especially in political cases, because we think the audience is the media or the client. So we speak with bluster and pomp. But your first audience is that judge. How well do you know them? Have you studied their jurisprudence on similar questions? There are some justices and judges, and I say this with the greatest of respect to the bench, whom if you told me, take this matter and argue it is before Justice so-and-so, I would say with the greatest of respect, please call the next person. I have taken upon myself to study and see, has this particular judge handled a matter like this before? What was their approach? Because it is unlikely they will depart from their frame of mind. When I was in law school many, many years ago, there was this unpopular subject called jurisprudence, in which there was this school of thought called legal realism. Now, many of us read jurisprudence to pass it, not to understand it, if we are being honest, now that we don't have to sit exams. You come out in practice and you realize that legal realism, in my view, is actually, to the everyday practitioner, the most vital school of jurisprudence, because it takes you back to understanding the judge, the frame of the mind of the judge, and how are they likely to lean one way or the other. The way I would argue before Justice Egon Nantende, who wrote Osotrako, dissented in Chigula, wrote the lead judgment in Tinyafuza in the Constitutional Court, would be very different from the way I would argue before Justice Sekoko. Two leading minds, different approaches. Let me use retired judges so that I don't get in trouble. The way you would argue before Justice Odoki certainly wouldn't be the way you would argue before Justice Wambuzi. If you've read Chief Justice Wambuzi's decision in Shah versus the Attorney General, you would be amazed at how much time he spent on basically splitting the English language. A constitutional question turned on English. Now, would I prepare the same way that I would for that judge as I would for others? No. If you appeared before Justice Kanyehamba, you knew that because of his character, a bit brutish, if he starts firing questions, don't argue with him. But have enough composure to get your point across. Thank you. Usually these things mean time is up. So I would say, understand your audience. and I will go here to a delicate point. I have said to justices of the Constitutional Court at this very venue down here at one event that, in my view, they are now they've recited what Professor Konyango called a subtle version of the political question doctrine. I have failed to understand the jurisprudence on whether or not a case raises a question for interpretation. Because we all go and cite the two decisions Mr. Ogalo spoke about, Ismaili Serugo and Tinyefuza. And panels using the exact same decisions we will find in similar questions. On this one, there is a question for it. On this one, there is no question for. My view, therefore, has come down to saying if your case has political implications, it has no question for interpretation. So study your audience. Who is your client? In the Isa case, my client, the people who approached me were Isa the NGO, but I believe that my client was all the persons with hearing disabilities in this country. No case in my career has taught me the importance of public interest litigation like that case, for personal reasons. You see, about a month after I got those instructions, my wife and I had our second child. And 10 days after birth, I sat across a doctor who said, this child will never hear a sound. She's a girl. Now, all the practical issues of persons with hearing disabilities made so much sense. You take so much for granted because you're full-bodied. If you're a parent, you know the joy of making pointless sounds with your child. There's a parent out there who cannot communicate with their child. When you have cases, please remember they touch real people. For every case is personal. For that, it would help you, by the way, she now hears, thank God. Every case will take a different touch if you view that client as your cousin, your brother, your favorite uncle, your niece. When I ask the question, who is your client? I am almost thinking about the now immortalized dictum of Lord Atkin in Dono E.V. Stevenson, where he sets a standard for negligence by asking, who is your neighbor? And your neighbor is anyone who could have foreseeably been impacted by those actions. You see these political cases we all ignore? I argue that Ugandan politics changed, and I don't mean to get political here, the day that Bobi Wine was tortured. You see, whatever your views of Kakwenza and his manners are, if the security forces can pick up a civilian, beat him to a pulp, arrest him and keep him in detention for a week, take him to hospital when he can barely walk, take him to court when he can barely walk, rather than to hospital, and that does not move you, please stop pretending to care about public interest litigation, but more importantly, God help your soul. Mr. Ogalo speaks of the days, and we've all read St. Paper versus the Attorney General. They sound like stories of long ago because almost 40 years ago. But you see, now you are the middle class. You think who is going to affect your neighbor? I always tell people, one of Kampala's biggest threats, in my view, is those security guards you all hire because you can afford. I was driving into my office once, and I know time is up, and I'm about to finish by that. And the security company, my landlord at the office employed at the time, had this guard who was called Sandy. He always saw my car from a distance and ran to the gate and opened and looked down. I always made it a point to lower my window, say hello to Sunday, and drive in. Many of us don't even have the basic decency to say hello to these people. There are also people like you. So one day, I came to the office at about maybe 6:30 p.m. on a Friday. And I hooted, and Sunday was nowhere to be seen. After about 15 minutes, I thought this was strange. So I asked him, he ran, and you could see the man was remorseful. I said, Sunday, are you okay? Mukama wange sonyiwe. I had taken enough. Mukama wange, I dozed off. I said, Sunday, what is the problem? He said, Mukama wange, nkole emirimu ebiri. Nkola wano emisana, nengena nenkola ekiro. Nabadde seebase, nsumagidde. I asked him, Sunday. He's looking down. I said, Sunday, bakuwa sente mmeka? Mukama wange emitwalo 12. I asked him, oyina omwana? Nina omukyala n'abaana 2. Bali mu kyalo mukama wange tondoopa, bagenda kungoba. Now, thank your God for you. 120,000 is not enough for the meal at Serena that you usually, out of habit, just have it really twice a week. That is someone's living. And they carry AK-47s these days. When the chaos breaks out, what do you think is going to happen? This man is going to go and shoot your neighbor's child. Every morning you're shouting at him. Now, that is why some of us do public interest litigation and speak out about some of these injustices, because Kakwenza is a proverb. It is not a name. By a proverb I mean Kakwenza could be you, your brother, your cousin. There are some things in this country you've allowed yourself to never be able to talk about, and yet you're a lawyer. So, who is your client? And who are the other stakeholders? I think it's a very important one before I wrap up. I suggest that you consider, when you're crafting your case, who are the other stakeholders. It will tie into the solution you want. Something I urge, especially younger members of the bar, because it has worked for me, find these giants of practice and public litigation and work with them. I had been in practice for maybe 14 years when I first interacted with Counsel Gallo. We handled the matter together, and when he shared with me, I volunteered to draft the pleadings quickly. Of course, when you are with Mr. Gallo and Mr. Alvin, they quickly say, "Iwaka naiwe, jokube mpapulolete," which is Chinese for "Boy, kuja hapa." And I did it with all the joy in my heart. I talk about only because they are here. Sigeya. And I know Mr. Alvin wouldn't mind these stories. Why did I do that? Because I wanted the benefit of their sharp eye. I have never seen clearer pleadings in public interest litigation, and I've done maybe 45 cases now, than the petitions that Mr. Gallo drafts. I changed my drafting style. 14 years in practice, it stands to reason to say I am not the shabbiest of them all, really. But when the man touched my pleadings, there is a kind of wisdom called experience. You don't get it in law school, you don't buy it in the market. But you can save yourself years of getting it wrong by simply hitting your wagon on something greater, as Barack Obama would say. I have benefited from having co-counsel. Sometimes being co-counsel is a double-edged sword. There are cases where you are co-counsel and you politely tell the client, "Zikiriza." Let me step aside. But I have worked with some of the finest and best and brightest. Nicolas Opio, Professor Mbazira, when we were putting together the amicus application in 2016, we had heated arguments about what goes in how. One of the reasons why we did that case, and I am really proud, Professor Mbazira told me, one of the reasons why I wanted us to do this case is to disprove this theory that academics can't practice. I am really proud that the Lord does. You know, the only academic people respected at the time was Professor Sempeo. Nena for all yao kati. Tomanya. Those people in those academic institutions know a lot. Sometimes you need them as expert witnesses. Now Justice Mubiru one time was giving us a lecture at LDC, and he told us the best witness he ever had in private practice was Professor Jogo. King Solomon said, wisdom in the heart of a man is like deep waters. A man of understanding draws it out. These men are not here by accident. But also think about creative remedies. That's how we got structural interdicts, and we now have, I think that the law on that is now fairly settled. This is how we got amicus rules because of PIL. I think it is now time to go from structural interdicts to meaningful engagement. And in meaningful engagement doctrine, the court becomes an active participant in actually solving the problem. When I spoke just as the Constitutional Court, they were divided on whether it is time to go for meaningful engagement or not. But I think it is time. It is the next layer to interdicts. And then there is the question of practical strategies. Do you conduct a litigation surgery before you go to court? I have been privileged to facilitate some surgeries. My brother Arthur, Sehat, Isa. And I think it stands to reason to say they have helped. Even I have learned a lot from them. I did one where my colleagues at Uripec said, come and play devil's advocate, punch holes in this petition. It did not help that I had been traveling all night the day before. I was grumpy, frustrated. I think the anger helped. That is the case that eventually I think turned out as no, it wasn't James Mohindo, but it moved the needle on one or two issues. And I am very proud to have participated. Ladies and gentlemen, it was Abraham Lincoln, in conclusion, it was Abraham Lincoln who said, if I have 8 hours to cut down a tree, I will spend 6 hours sharpening my axe. I believe that cases are won through strategy. And I believe that you settle your strategy, you concretize your case, you frame your argument, you paint your picture before, and then you draft your pleadings. My parting shot is going to be, and the judge said this to me, I'm going to part with 2 shots. One is, I was out of the country once and I was meditating on something. Have you ever asked yourself why lawyers have no coaches? If you think about the greatest athletes of all time, I mean, you could pick anyone, Michael Jordan. There is that famous picture of him standing and he's looking down at his short court. One of the best basketballers of all time. You could pick a living legend. Eliud Kipchoge. What's the name? Kipchoge. I think lawyers need to learn from, especially in public interest litigation, these matters which we don't really do for the money. I would suggest to you, in terms of improving your art and skill as a public interest lawyer, to learn from these sports people. Eliud Kipchoge still has coaches, and very importantly, pace setters. A clique that runs around him just to make sure he is the man that he is. No man is an island unto himself, but even the island needs the water. I would say you would do yourself wonders by getting a coach or two to help you improve your strategy and your drafting and your argument and the art of lawyering and things like that. But I would close with a parting shot that a judge friend of mine, well, a judge said to me, maybe I shouldn't call him a friend, when I approached him and had this question about coaches. He said to me, I'll give you a tip right now. We know that you know what you're doing, but here is the mistake most members of the bar make. They don't focus on pleadings. Focus on your pleadings. It all starts and ends there. Judges have said to me, the quality of our pleading has gone significantly down. And yet, as far as they are concerned, they frame their mind on how to approach a case from the clarity of the pleadings. I hope I have said one or two useful things, and I thank you very, very much for the invitation and for your kind attention.
Thank you so much, Mr. Chirunda, for that very insightful presentation. Thank you for sharing those nuggets of wisdom. Ladies and gentlemen, in the course of the presentations, we were joined by the president of the society, President Bernard Oundo. You're welcome, sir. I saw of your people, when they saw you walk in, they beamed with a smile. And it's on that fall that I'm sure they're anxious to hear a word or two from you. Thank you.
Thank you, Gabriel. You know, he mentions and says, my people. And I want to correct him and say, my people is Uganda Law Society. So I no longer have my people. My people is Uganda Law Society. So allow me, I know that my remarks, I think, were shared by our representative to the East Africa Law Society Executive, but just allow me welcome the East Africa Law Society back to Kampala. Vice President, you're welcome. CEO, you're welcome. Our Kenyan colleagues, Evans, Ogada from Kenya, thank you, you're welcome. And welcome back the East Africa Law Society to Uganda. Allow me also on a very special note, recognize our senior counsel here. And I want us to do one thing. One of the things I have learned is gratitude. I want us to clap for them and applaud them for the work that they have done. You know, it's very difficult to speak after my brother, Chirunda. It's very difficult to speak after him. And so sometimes I tell him that, why don't you just launch your manifesto and we understand? But we also must applaud him for the excellent presentation that he has shared. And as always, when he speaks to your heart. And if you didn't have any plans to take a public interest litigation case, I'm sure while you're here, you're thinking about which one I should be looking at. And he also always inspires me, and I continue to walk this journey. But I must also remind you, now that he ended with a quote, that President Eisenhower, if I'm correct, if it wasn't Eisenhower, then it must have been John F. Kennedy, said, do not ask what your country can do for you, but ask what you can do for your country. And I think as the East Africa Law Society brings conferences and trainings like this on strategic litigation, it is not just a training for you, but it's also a call for you to do something about what we see and what we keep reading in the newspapers and what is perhaps happening around us that needs to be changed. So I want to place a clarion call on you today that I hope that after this training, you will not be the same. But more importantly, that we will see more faces, we will see more members participating and supporting the strategic litigation role of the Uganda Law Society. That is my call for you today. As the Uganda Law Society, you know, we have a number of cases. And if you want to volunteer, and I want to make this call, if you want to volunteer, please reach out to the CEO. We have cases on the Computer Misuse Act. NEMA was also threatening. I think they have backed out, but we're also ready, you know. So we have a number of cases that the Uganda Law Society engages in. So today I want to ask you that if you want to volunteer, if this training has impacted on you, please ensure that you reach out to the CEO and volunteer. Not only to the CEO of Uganda Law Society, but also the CEO of the East Africa Law Society. Having been president of the ELS, I know that we also need support with the East Africa Law Society. Let's volunteer and make a difference. I know that it is time for break, so with those few remarks, I want to thank you for coming. I want to thank you for registering. Let me thank the East Africa Law Society, the Vice President. Please send our regards to the President. Where is our representative, Naomi? Oh, she's there. I hope you all know our representative. Let her wave so that you... That is our representative of the East Africa Law Society. So I also want to thank her and the team from the East Africa Law Society for bringing this training here. Thank you so much. Asante sana.
Thank you, Mr. President, for those remarks in which you hinted on one very, very, very important item that is very vital to us at the moment, which is a tea break. So colleagues, I think having mentioned that, we are going to break for tea for about 15 minutes. If that's okay, we could pick our tea and then come in. Because we're running behind schedule, we have still quite a couple of presentations to go. So I'm going to request we can get our tea and then come back in. After the tea break, we have quite an interesting lineup of topics for you. Amongst them is choice of forum at the regional level. Are you interested in litigating at the ESCJ, the African Court? This is your session after the tea break. But before we go there, we're going to have a group photograph right at the front. So if you don't mind, if I may indulge you for 1 or 2 minutes to come to the front and take a group photo. So we can do that in about 2 minutes. The photography team is ready. You can come set up quickly so that we have our tea break, and we are expected back by 11:50. So Mark, if you don't mind, you can come and set up. Captain, I understand. The tea break is of paramount importance, but I think we should have a group photo then a tea break. Thank you. Colleagues, let's come to the front and take this photo. I promise it will be as brief as possible. Thank you. Okay, we can move to the front.
into the hall. We are behind schedule, so I'll request that we begin. Thank you very much for coming back for the second part of our session. I believe with the tea break, we now have renewed energies and we should have a better session. Our next session is a panel where we're going to have two interesting gentlemen, one from East Africa, one from Uganda, and the other from our brothers in Kenya. I believe Kenya is now much better. A few weeks ago, the stories we were seeing on the news were something else. I was wondering whether my brother, the VP's law firm, is safe with all the riots that were going on, but it's good to see in one piece, Bwana VP. I've been asked to introduce the team here, and allow me take the pleasure of introducing. I'll begin with Professor Sempewa. Professor Sempewa is a distinguished member of the Uganda Law Society. He has served as the president of the Uganda Law Society. He has also been one of the leading members of our academia over the years, where he has taught several members of the legal fraternity. He's also an author of various constitutional publications, including the Constitutional Debate in East Africa, several journals, and he also had time in academia at Makerere University. He was also a senior lecturer with the University of Zambia and the University of East Africa in Dar es Salaam. He was also a member of the 1982 to 1985 Uganda Constitutional Law Commission, as well as the chairperson of the Uganda Constitutional Review Commission of 2001 and 2003. Professor Sempewa has been a vanguard of public interest litigation, both within Uganda and the region. For us, within the country, Professor Sempewa has previously been our chairperson of the Rule of Law Committee. During his tenure, we introduced the launch of our quarterly Rule of Law reports and had several interventions under his guidance. He has also been one of the leading advocates from Uganda, litigating in the East African Court of Justice on behalf of the East African Law Society. I had the pleasure of serving with him on the Research and Litigation Committee of the ELS, where we used to render with CEO, where we used to render our research to our senior litigators. He has also been part of several leading constitutional cases on revenue law, taxation, constitutional law contracts, conveyance, among others. He's also a senior draftsman who has been part of several legislative processes, contributing to legislation including rules, the Uganda Communication Commission rules, Tax Advisory Committee rules, among others. He's also one of the founding partners of one of the oldest firms in this country. Him with Senior Counsel Katende started one of the oldest firms in this country that has spanned to over 40 years of practice. Their firm has a vast area of practice with a very big clientele that cuts across jurisdiction. So it's my pleasure to introduce Professor Sempewa as one of our panelists. Professor, we are always glad to have you, and we are glad that you've accepted to share your experiences, your vast knowledge with the membership of Uganda and of East Africa. Thank you very much. Allow me also introduce my brother from Kenya, Mr. Evans Ogada. Mr. Ogada, the names in Kenya are very similar to names in Uganda, so for us, it's very easy to pronounce Kenyan names. There's a lot of similarity between Kenyans and Ugandans. Mr. Ogada specializes in constitutional and administrative law litigation. He has handled numerous cases in the area of representing the Law Society of Kenya, which is one of the most vibrant societies when it comes to public interest litigation. We must applaud the Kenyan Law Society. On issues, they've had petitions on the appointment of judges, petitions on arbitrary arrests. He's also a member of the Law Society of Kenya Public Interest Committee. He's a member of the Law Society of Kenya, Nairobi Branch Constitutional Review Bar Bench Committee. He has worked with Chitiba Institute, one of the leading Kenya public interest litigation organizations. He teaches public law at the University of Nairobi School of Law and serves regularly on the Civil Society panel on the rule of law and international criminal law. He's an associate editor of the Platform for Law, Justice and Society, a leading social publication in Kenya. He's highly educated with a bachelor's degree, postgraduate diploma, and a master's in the disciplines of law. He's an advocate of the High Court and all subordinate courts, all subordinate and superior courts. It's my pleasure to introduce Mr. Evans Ogada. You're welcome, Mr. Ogada, to join the panel. At this juncture, my work was only to introduce. Allow me hand over the session to Gabi Naume. To lead our panel through the discussion.
Thank you so much, Mr. CEO. I'd like to hand over the discussion to Professor to start his session. Thank you.
Thank you very much for the introduction. A lot has been said about me. Someone can assist me to change the slides because I can't see it from here, but I'll be giving direction. So it's now my turn also to make some introductions, at least one introduction. The East African Court of Justice was established, and for 4 years, I think it was 4 years, it had no business. But mainly because no one was knowledgeable about this court. Even the judges themselves were not so sure about their role. So it could have gone on like this, except that at one time, one of us in this room was a member of the East African Legislative Assembly. And members of the Legislative Assembly had some conflict with council. Council is the equivalent of the executive. Not quite, but you can say the equivalent of the executive. Council was trying to grab some of the roles of the Legislative Assembly. So a few members from Uganda and Kenya came together and said, why don't we try a case before the East African Court of Justice. And so we had meetings in Nairobi, and we concretized on the first case in the East African Court of Justice. And that person is, although he has refused to be referred to as Honorable, Wandera Ogalo, with whom we argued the very first case before the Court of Justice. And people have been talking about the value of public interest litigation. Let me add a voice. It's not only success, but also learning. Because you learn a lot, especially when the matter you take has some complications that you will not find elsewhere in your litigation work. You learn a lot. We learned a lot about the procedures in the East African Court of Justice because this was our first time. And we thought we shouldn't make any mistake. But I'm also sure the court was pleased because for the first time they had business and they are willing to entertain us. So learning is a value that cannot be costed in terms of money. The other value is, of course, profile. When you appear in those very sensitive cases, especially when you are successful, your profile raises. And you can use this profile to gain business that brings in money. Everyone gets to know you. I'm pleased that Robert talked about the death penalty. Death penalty gave us a lot of profile. I attended several conferences where I introduced myself as a lawyer from Uganda. And several people said, death penalty. I said, yes, I appeared there. I couldn't even hide my pride. Normally I'm a bit happy. But because of this case, I strode around. You can't underrate the profile. So we would argue lawyers to join in, especially because your profile will be raised. If you stay in Chibanja cases and murder, so no one will ever get to know about you. But these public interest litigation cases normally attract a lot of public attention, and you get to be known. Finally, you are sensitized. Robert was talking about feelings, getting involved. When our firm decided to take on the death penalty case, I was one of those who said, why? Because I had grown up knowing that a murderer must be killed. This was my life. If you have committed murder, you die also. So we had a long argument about this until the firm said, no, let's take it. After reading a few precedents, and particularly after interacting with people on death row, you should visit. Well, now it's not so important because we almost managed to go out the death row. If you visited those people on death row, you would really be involved with them. These are people who have been condemned to death and they are waiting to be hanged. There's no situation worse than that. Because every time you wake up, you wonder whether it is today. Then you wake up the following day and you wonder whether it is today. and were telling us tales of days when people would be dragged out of cells and there would be yells. People were taken away to await hugging. It was terrible. But also we found out that so many of the people on death row were innocent. Of course, you may not believe it. You say that every convict will say, I'm innocent. But there were real tales of truth, innocence. It's about two people who were condemned, sentenced to death for killing people, who later suffered and were walking around. They had gone somewhere in hiding. Anyway, for the topic of today, I'm going to talk about the East African Court of Justice as a choice of forum. I'm going to be difficult, but I'll manage. The first slide there is about the court, how the jurisdiction arises. Normally it is informed by the objectives of the regional integration agenda. In our case, the agenda touches people as well as markets. And it touches people because they are beneficiaries of the integration. So the treaty that sets up the court or sets up also the East African community brings about those milestones that you are aware of: the customs union, the common market, possibly the monetary union, and the political federation. I wanted to mention that there are other initiatives in this area, Eastern and Southern Africa. That is, we have the COMESA Court, whose agenda is almost similar with the East African community. We have COMESA, and COMESA has got a COMESA Court, where I've litigated once. There was a SADC tribunal. The SADC is the initiative that covered the Southern Africa. But one of the partner states, Tanzania, is a member of SADC, whereas it is not a member of COMESA. I think now Congo also is a member of SADC. The other initiatives, of course, is the African Commission and the African Court. These deal mostly with, solely with human rights. Next slide. Maybe it was wiser to sit, because then I can read my notes, refer to them. Just excuse me, I'll go back. No, I didn't. No, I can do it. I prefer to stand. Now, why do we go to a regional court? What are the reasons that draw us there? Where regional courts are believed to be freed from sensitivities of their national courts. Robert was talking about self-restraint, I think even Dan, self-restraint. That arises from local sensitivities. If now you took a case, let me talk about a topic which is not very safe. If you took a matter that has got to do with the current homophobia to court, you are dealing with these local sensitivities and you might not get full justice. But if you went to a regional court, or even a continental court, that we may not be a problem. Secondly, these regional courts normally are jurisdiction specific. They have one item. And so you go there expecting that the court will specialize on that item, whether it is human rights or integration, economic, and therefore it can dispose of the matter with all due expertise and also with speed. But that can be a bit of a perception, because we've seen that sometimes matters delay in these courts, especially the African court, whose procedures are a bit lengthy. I think those are the main ones. The drawback, of course, is that some courts, like the African courts, have got conditionalities like the exhaustion of remedies in local courts. And the other drawback, of course, is enforcement of judgments of regional courts. That is something we have to discuss and also lay down strategies for challenge. Because we set up these courts and we should respect them. The partner states should respect them by obeying their orders. But that's not normally the case, so enforcement could be a bit problematic. Now, the South African Court of Justice, if you want to go there, you must be sure about the jurisdiction. Many cases have flopped there because of jurisdiction. This court is set up to interpret the treaty and to apply community law. Interpret the treaty and other community instruments and apply community law. Are we together? So when you are framing your cause of action, you must make sure it falls within this jurisdiction. Of course, the treaty says that the court will have other appellate and human rights jurisdiction as council may decide in the future. But for the time being, that is the jurisdiction. There is a new protocol to extend the jurisdiction of the court, which is now being finalized by all of signature and I think ratification. But has added nothing really, very little, because people expected it would be adding a clear human rights jurisdiction. It hasn't. It is simply authorizing the court to interpret and apply the common market rights, which the court had already done in 2 cases. And in any case, the national courts are already authorized to deal with these matters, although many of our people don't know. And that is something we should be aware of. But as jurisdiction is important, frame your cause so that it falls within the interpretation of community instruments and all the application of community law. And it follows, therefore, that the sources that you are looking at, the principal sources of law, are, of course, the treaty, the protocols under it, other protocols, besides that, we have acts of IALA, which landed Ogalo 13, acts of IALA. These are principal sources. Now, the community is so framed that there are two legislative centers. IALA, East African Legislative Assembly, as well as Council. Council can issue binding regulations, directives, decisions, which you should be aware of as sources of law. Of course, there are precedents of court. You can also rely on international law when you appear before this court. International conventions, instruments, and general principles of law. That is your source of law. Plus, of course, rules of procedure. My friend Evans will talk about the procedure before this court. Now we have two. We began with one level, East African Court of Justice. Now we have an appellate level, which came up under very rather unpleasant circumstances when these Kenyans, they are members of Parliament of East African Legislative Assembly, were stopped from legislating because they hadn't elected them properly. So there was a court case, the famous Anyang' Nyong'o case. Of course, the court gave an injunction, and this annoyed Kenya. Immediately, the president sat and amended the treaty wrongfully without any consultation. And among the matters that were introduced was an appellate court. Then their intention was to appeal, but there was no appellate division. They wanted to appeal. That was the main cause of the amendments, hasty ones. Others, of course, targeted the Kenyan judges who had been on this panel that decided on the injunction against Kenya. They wanted to have to deal with them. You know what dealing with them means? Yes. So now we have, it's welcome. We challenged the amendment procedure and we succeeded, but the amendment stayed. The court said, they call it what? Prospective annulment, something like that. I don't know what that means. Now, you read in the treaty about the manner of selection of judges and so on. One thing is clear is that the judges now we have in court are really seconded from our judiciaries. But I think it is high time that we had independent judges there. First of all, the business has grown. But secondly, we want people who can concentrate on the court on the court business. And these judges have no time. They keep changing. I was looking at the judges of the appellate division yesterday, and now I see new names appearing in a case that had started with another panel together. The system of appointment is not so transparent, but you have to do with what you have. To add to what Robert and learned friend Ogalo said, these judges, you must be careful. You must study them carefully. This is particularly important because these judges, they come from every partner state. As soon as Rwanda and Burundi joined, we had judges from Rwanda. and judges from Burundi. And believe me, the judges from Burundi were not, you know there's emphasis on the common law tradition in this court. And the judges from Burundi were a bit lost. Can be a problem. I remember when I first appeared in the Comesa court, which was situated then in Lusaka, the judge president was from Burundi, and this was his first case in the Comesa court. The other judges were still in the common law tradition except himself, and he was completely lost. As soon as I started submissions, he said, "Counsel, can we now discuss damages?" I was just introducing the facts, and he said, "Can we discuss damages?" I said, "My lord, but I haven't gone for." "Yes, but this is about damages." So we are going to have a bit of a problem. Now we'll have judges from not only from South Sudan, but from DRC. DRC is now properly a civil law jurisdiction. Very different from the common law jurisdiction. I'm not condemning the civil law jurisdiction. I don't have the attitude of the British, because for them they are insular, everything good is British. What we lack here is to study that system, the civil law system, and grab what is good in it. But for the time being, we'll have the trouble with those judges who cannot follow. I've talked about the jurisdiction. I want to be quick. Now, you should also be aware of the extent of the court's jurisdiction, because there could be blunders. I put there in F, slide F, what you should be aware of. The treaty emphasizes equality. So the court does not sovereign equality. The partner states retain their sovereignty. They have ceded some, but they retain a considerable degree of sovereignty. So this court does not have an appellate jurisdiction. People have tried to go there to appeal, but does not have an appellate jurisdiction. Does not superintend national organs. They are still free to operate, pass laws, provided those laws do not conflict with the community law or community objectives. And of course, community law takes precedence over national law. There is no possibility of government or anyone else to argue local law in defense of community law, as happened in one case of a Kenyan who was grabbed at the airport at Entebbe, detained. He had a beard and so on, so the immigration said this must be a terrorist. So they grabbed him, detained him for several days, and then deported him. When he brought a case against the East African, against the Uganda before the East African Community Court, the Uganda government argued that we have our own immigration policy and laws, and we are using them to deport a person who was suspected of being against law and order. Of course, they failed because of the requirement of free movement. We've been talking, by the way, I don't know whether all of us are aware of the community law. Maybe I'm assuming too much. Which people are aware of community law? Who have heard about the common market? The common market rights, free movement of people, free movement of goods, free movement of capital. And so this case now concerned the free movement of people. And the Kenyan Mohochi was asserting his right to free movement, which had been violated. He could have sued in the local court, but it was better to go to the East African Court of Justice, because these sensitivities, local sensitivities, will not be there. But our court, the East African Court of Justice, has gone very far now. Although I'm talking about its lack of superintending local organs. But there are cases where it has gone far to hold that, to hold that a local court, a national court, and this has something to do with the rule of law. Very serious, that a national court must follow due process because it is part of rule of law. And this falls within the core values of the community as enshrined in Article 6. There was a case from Burundi, I think I cited it there. Have you seen it? Nawario, where this was pronounced. So the court has been a bit generous. It is something you can use even when our courts blunder. If you can frame your cause of action, there's no appellate jurisdiction, but frame your cause of action so as to fall within the treaty and community law. You see the difference? You don't appeal that I didn't have a due process. You simply say the local court is an organ of state, and I'm challenged at this organ of state's compliance with the core values under especially Article 6. You are all aware of Article 6, it's a very important article, especially 6D. You are aware? I think we need to do a lot fast. Article 6D, I wish we had the treaty with us. I assumed, is that the treaty? Can I have 6D? Article 6D spells out one of the fundamental principles. I call them core values of the community. These are values which must govern the activities of the community. And there are several of them, but 6D is very important. It says it is a core value. Good governance, including adherence to the principles of the rule of law, accountability, transparency, social justice, equal opportunities, gender equality, as well as the recognition, promotion, and protection of human and people's rights. So much of public interest litigation can be based on the core values, especially in Article 6D. And much of our litigation so far has been based on Article 6D, core values. Please have the treaty and make this your Bible, as well as the principal protocols of the customs union, the common market, well, the monetary union, and not so much, but it's good to learn about it. I'll skip those examples. You can read them on your own of interesting contrast on one aspect of election of EALA members, where in the Kenya case, the court said, violation of Article 51, Kenya did not elect, because the article says National Assembly shall elect. But the procedure they used, they did not elect. I think they just put names together and as usual in the National Assemblies, those say aye and so on, these members. But then in another case, Mutikira, the court says, yes, we see an election, although it was unfair. So we have no jurisdiction. It's the local courts which have jurisdiction on the fairness of an election. That is by interpreting Article 51. And the last case, those are interesting cases to read on your own on jurisdiction. I should mention now a very important aspect of appearance in this court. Time of limitation. Again, this came out of the amendment of the treaty after Nyang Nyong'o. Before it didn't exist. Now there's a time of limitation of 60 days from the time the cause of action arose or from the time you got to know of the cause of action. Why is this important? It's important because the court has interpreted it very, very strictly. To the extent that the court does not recognize continuing torts. Once you have been arrested and put in prison, the cause of action has arisen. You cannot argue that each time I'm in detention, the cause of action is arising, which is absurd. I think in our local laws, the tort continues, not so? But before this court, no. The first instance decisions were that time of limitation should not apply to continuing these continuing acts of violation. But when the appellate court came in, they said, no, there's nothing like that. And I think they were trying to please the powers that be that had brought them into existence. But that is what we have now. All right. My friend will deal with a lot of other aspects. But I want to conclude by mentioning two matters. The prospects. The prospects are wide. Prospects of litigation before the East African Court of Justice. What we have had so far is litigation on human rights. That is the majority of cases. I mentioned that this court strictly, on interpretation of the treaty, has no human rights jurisdiction. because the article which gives it jurisdiction says it will have this jurisdiction in the future. But good enough, the court has interpreted itself into a human rights jurisdiction by stating that if there's an infringement that falls within a violation of the treaty, then they have jurisdiction. They have gone to great lengths to define this jurisdiction. And strictly, if I was a judge, I would say, but whatever you do, I would dissent. Whatever you are saying, however you frame it, what you are doing is actually to entertain human rights acts. And this is now so evident that because from the time of inception, the court said they will not give compensation. But then a case came up, I think it was Chalimpa, and the judge said, our jurisdiction will not be effective unless we can give reparations. Then following that, there was a Ziwa case, and they awarded damages. Not so, my friend. They awarded damages. Then very recently, they awarded hefty damages to a Kenyan, Martha Karua. Martha Karua is part of us. She was a very active member of the East African Law Society before she joined politics and became a running mate of Raila. Yes. And they lost. I always warned her not to join politics, but she did. So there are a lot of prospects. One of the areas that remain untouched is the area of economic rights. These are rights arising out of the common market, where our people are oppressed day and out every day. The governments are violating all the rules relating to the common market. They keep maintaining tariff barriers, non-tariff barriers mostly. They quarrel and close borders without telling us why they are quarreling. They chase out chicken from one area. You know, it is even funny that you can chase out animals. That these are Kenya animals. Go back to your area. We don't want the cattle from Kenya. Quarrels like this is Uganda milk. It will not enter Kenya because we are not so sure it is Uganda milk. What else can it be? But this is it. Uganda maize is full of toxins. Don't bring it. And no one is challenging it. What we have is bilateral talks to reach a consensus. And then the violations continue. Can we, as the East African Law Society, target this wide area which has not been targeted before? Because many of our people are not sensitized, but they also do not have the ability to go to the East African Court of Justice. So this is a big area. We have also areas of lack of transparency which affect our people greatly. Take this aspect of admitting new members to the community. Which of you know how they admit these partner states like South Sudan and DRC? There is a procedure under the treaty. What a country must do to qualify. And one of them is to be compliant with Article 6D, which I've read. It must have good governance. You remember what I've just read? Of course, one may ask, how can, maybe I'm being unkind, but if your house is full of soot and you are trying to chase out people who will bring in more soot, no one will believe you. But anyway, that is a requirement. But which of you knows how they do it? How South Sudan qualified under this Article 6D? And how DRC qualified? DRC. Can you imagine? Now we are talking about Somalia, and they will do it in about a week or two. Somalia now is a partner state. It's ridiculous. But also there is consultation of people within the new prospective partner states. That's important. In Europe, all this is done. You can't assume that the people in the prospective partner states are happy that they are joining the community. I'm saying so that because South Sudan, when it was being considered, a big section of South Sudanese intelligent people objected. Do you know why? They had very good reason. They said, look, all these partner states have a head start over us economically. And we are entering a tariff-free regime. We shall end up by being a market for their goods. Unless we are given time to catch up and also have our own products that we can sell. But now we don't. Is that not a good argument? Because you're entering a tariff-free market, which means Kenya can send in goods, Uganda can send in goods, tariff-free, tax-free, and so on and so on. And this was one of the quarrels that led to the collapse of the first community. Because Tanzania thought that Kenya was gaining too much, was sending goods to Tanzania, whereas Tanzania had very little to send across. So these are matters that needs to be explored for us. Now, East African Law Society, we have a strategic litigation section, don't we? So please join us. Just approach the Rule of Law Committee, approach the CEO to see how you can join us and assist in this litigation. Further, there's been training of several young lawyers in this public interest. I think I saw someone with whom we were in a recent training. Did I see Juliet, or did I see wrongly? Oh, I saw you, yeah. She has just gone through a training. We have this training in Arusha every year. And this is a cadre from which we should draw. David, can you approach these trainers, because this is a cadre. They come out every year. And they are a good source to tap to join the public interest litigation. They are trained specifically in this area. So I'd not like to deny my friend time. I'll stop there. If there are questions, we shall answer them. Thanks very much.
Ladies and gentlemen, we can do slightly better by applauding Professor Stefan. So our time is well spent. My name is Uganda. The protocols were done. I salute the leadership of the East Africa Law Society, Naomi Bia Zaire, Always good to see you. Vice President, the reason why you're an old man and my mother was born in Uganda, by the way. She lived in Jinja, a place called Namsagali. The reason why those old men came to Uganda. So we need to ask ourselves, why is it that our men were flocking back to Uganda? Today I see the reason why. So some of us who are senior bachelors, senior council bachelors, we need to perhaps open our eyes brighter. Good afternoon. Please say hi to your neighbor. Shake your hand, the hand of your neighbor. If you can, please stand up, stretch for a little bit. We've been sitting for some time. We have very few minutes. Thank you very much. Now, Professor Sepembo has gone through what I wanted to address. Sorry if my presentation would sound like a teacher in class. I am a teacher in class. I teach at the University of Nairobi. So if you probably find yourself bored to death in an afternoon class, you're in the right place. Don't worry. Thank you very much. Now, the choice of forum. When I saw that this took me to the second facet of international law, which is private international law. I grappled with how to present this, my good friend Mr. Munabi, but I understood the assignment by looking at the concept paper. Basically, the choice of forum, this will lead us to asking ourselves questions about the jurisdiction. So what is jurisdiction, my brother? If I will ask you, what is jurisdiction? Yes, I told you this is a class, so questions will shoot. Don't worry, as he catches his breath, jurisdiction simply means the authority to speak about the law. It is a fusion of two Latin terms, juris and dictio. Juris meaning the law, dictio authority to speak about the law. So when you go to the East African Court of Justice, ladies and gentlemen, Professor Sepembo has gone through that. Think of what can this court speak about in terms of the law. And Professor answered that by telling you that you need to focus about the community law. We will not go through that again. How do you discern what will bind us as community law? International law principles, and he referred to, aside from community law, we have sources of international law, which from our public international law, which are the sources of international law, my sister? Sources of international law. And then you speak like you're addressing the Lord Mayor of Kampala. Where do you get them, the sources? Article 38 of the International Covenant on ICJ Statute. You remember that? You remember that? So you start with the treaties, you look at customary international law. That is an area that has not been explored. We certainly have our customs within the region. If you look at Kenya and Uganda interacting for the longest time ever, the communities around the region, we've been interacting. We have aspects of our customary international law. Let us explore those. How are we bound by what we call law? I will want us to look at Article 11 of the Vienna Convention of the Law of Treaties, 1969. Tuko pamoja? Are we together? Oh, I'm speaking to Ugandans. Tuko pamoja in Swahili means, are we together? How do you say that in Luganda? Now that I want to talk to a Ugandan lady, Rua? That's what he said. Thank you very much. So, the jurisdiction of the court that has been looked at, the ESC rules, and the treaty, very important. The jurisdiction, please, those who are taking notes, look at Article 27, Article 32. Disputes between the community and its employees, that was not covered by Professor Sepembo. Disputes arising out of arbitration, that is Article 32, that was not covered. Interpretation and application of the treaty, that was extensively dealt with. Disputes arising out of a commercial contract, Article 32, look at that as well. The jurisdiction on human rights, Article 27.2. This has been well litigated in court. The jurisdiction to render advisory opinion. And please note that under this jurisdiction on advisory opinion, the summit, the council, or a partner state can approach the court. So not every Tom, Dick, and Harry can approach the court for an advisory opinion. So you have to note that in terms of locus standi, it's the summit, the council, or partner state. Locus standi and matters of procedure, who can go to the court to file a reference or to seek remedy from the court. Article 30 sabbatical 1 of the EACJ rules provide that any legal or natural person who is a resident in a partner state has standing to refer a determination to the EACJ. So a legal or natural person, and when I speak of legal or natural persons, I believe our laws are similar here. Who is a legal or natural person? What's the distinction between the two? Can you hear her from behind? Gabriel, can you hear the sister? Speak like you ate some matoke in the morning. Can you give her one solid hand clap? One good one. She got it. So that's a competent person for purposes of ESG jurisdiction. Then we have a resident of the ESC partner state. Who is a resident? That has been subject to litigation. We've had people who are originally born within the ESC, reside in a country for some temporary period. When they apply, they are struck out because of technicality. Professor Sepembo has once raised that with me. This is an area that we need to think and test. Who is a resident? Does it mean that when you go out there, you cease being a resident for purposes of locus standi of the East African? You can only go to court to challenge the legality of an act, the regulations, council decisions, directives, decisions, actions of a said partner in court. Article 37 of the treaty allows the parties to be represented when they appear before the court. Allows the parties to be represented, meaning that they can appoint counsel to represent them in court. That is for purposes of procedure. Ladies and gentlemen, mine was just a top-up. Thank you very much. And I hope those of you who are grappling with the issue of public interest litigation. How many remember the German theologian Martin Niemöller? Martin Niemöller? Ugandans, my good friends. My mother comes from this country. Martin Niemöller? The socialist, Martin Niemöller, is famous for a poem, and this poem is titled First They Came. So Niemöller talked of first they came for the socialists. I did not speak up because I'm not socialist. Then they went for the Jews. I did not speak up because I'm not a Jew. Then they went for the trade unionists. I did not speak up because I'm not a what? Then they went for the Ugandans. I did not speak up because I'm not Ugandan. Finally, they came for me, and there was no one to speak for me. So the fire in the belly, the ability to speak truth to power, is animated by our common humanity. Stand up, speak up, defend the principles, look power in the eye and say, this is principle, and we'll stand for it. Thank you very much.
Thank you very much, Mr. Evans. It was very, very brief, and on time. Thank you so much, Professor, for that insightful discussion earlier on. Would like to call the next speaker. The next speaker is a senior legal advisor, strategic litigation at the Uganda Association of Women Lawyers, also known as FIDA Uganda. For 7 years, she's working with the human rights litigation and is a member of the Feminist Litigation Network that collects a pool of female lawyers across Africa to practice public interest litigation. Ladies and gentlemen, please welcome our next speaker, Mrs. or Miss, I'm not too sure, sorry, Susan Baluka.
Thank you very much. Good afternoon to you all. All protocol observed. Very grateful to be given the opportunity to stand before you all great ladies and gentlemen, and even more humbled to be given the opportunity to speak in the same room and on the same platform as people who are my betters and seniors in this field of the law. The task that has been given to me is to speak to choice of forum, specifically looking at domestic courts. And because I believe I'm the one standing between you and your lunch, I'm the one standing between you and your right to food, since we are talking about rights, I will make it a point to be brief and succinct, especially given the fact that a lot of the issues have actually already been highlighted. So, in terms of choice of forum, of course it is very important, as has already been highlighted, when you are preparing for your case in strategic litigation or public interest litigation, it is important for you to make the right decision as to which court you are actually going to go to. And this is a decision that you will definitely have to come to at the point of case preparation. So that advice that Mr. Chirunda gave us earlier on in the morning about actually examining what the issues are and what the case is about is very, very important, because it is during that time that you will come to appreciate which court you ought to go to, because the nature of the case that you intend to file will influence the decision on which court you will go to. So in this presentation, we're basically going to look at what the legal position is in terms of jurisdiction of the High Court and the Constitutional Court over cases that raise issues that have to do with human rights, cases that raise issues of public interest and constitutional interpretation, and what are the challenges that have arisen for those of us who are human rights litigators. What are the recent trends that are causing challenges for us? So, of course, the decision on which court to go to is primarily, requires you to look at what is the jurisdiction of the courts that I'm considering. So when it comes to public interest litigation, with specific reference to issues that have to do with enforcement of human rights, we have Article 50, which basically gives locus standing to any person or organization to bring a suit or institute a case before a competent court, which, because of what Article 137 then stipulates, somehow it has become the norm that when we talk about competent court, the court that is being referred to in Article 50 is the High Court. And so that gives you, as a human rights litigator, even as someone who has been contracted by an NGO, as usually is the trend and practice, to actually go before this court to institute that case. Still looking at jurisdiction of the High Court, we have the Human Rights Enforcement Act Don't know, maybe if we could move on to the next slide. Yes, we have the Human Rights Enforcement Act, which was passed in 2019. And Section 3 of that Act reiterates the right of redress before a competent court. While Section 3.2 again reiterates the locus standing. Jurisdiction in this case is going to be looked at alongside locus standing, because that is going to speak to some of the issues that are rising currently, as we shall see later on in this presentation. So Section 3.2 still goes ahead to reiterate the locus standing of any other person who may not be the one who has experienced the violation, but any other person, please note that any other person, including a legal person like an NGO or any other entity that is going to bring a suit in the interest of a group or class of persons. And of course, now Section 4 categorically speaks to the High Court having jurisdiction to entertain cases that speak to enforcement of human rights. Then we are going to look at the jurisdiction of the Constitutional Court. Just to highlight, I know some of these things may already be obvious to us, but it is important to lay the ground before we go to the main issue that is causing problems for us today. We look at Article 137, clearly stating that any question as to the interpretation of the Constitution shall be determined by the Court of Appeal sitting as the Constitutional Court. And then it goes ahead to provide under sub-article 2, so rather sub-article 3 of 137, which says that any person who alleges that an act of Parliament or any other law or anything done in or under the authority of any law or any act or omission. So from the onset, when you look at Article 137, you look at Article 50, and even the sections within the Human Rights Enforcement Act, it's not obvious what is what, because if I want to challenge the constitutionality of something that has been done by an authority or person acting on behalf of the state, which is usually the respondent in human rights or public interest cases, it can still be an issue of human rights violation, and it can still be an issue of human rights enforcement, and vice versa. So for those of us who recall our constitutional law classes, that was an issue that was very contentious, especially in the early 2000s, and it was an issue that was determined in cases of Ismail Serugo and Major General David, also the cases of Major General David Tinyefoza versus Attorney General, where they clarified and said if not every case that raises issues of violation of the Constitution actually raises issues of interpretation of the Constitution. So the Constitutional Court in those cases made it very clear that only when there is a legitimate interpretation of the Constitution that is required will the Constitutional Court have jurisdiction to handle that particular case. And only when there is no contention as to, when the contention as to whether or not something is unconstitutional and it's only an issue of a right has been violated, is when then the High Court will have jurisdiction to handle a case. But then here comes Rule 7.2 of the Human Rights Enforcement Rules, which are rules that were passed under the Human Rights Enforcement Act of 2019. It comes in and says that a public interest action under Rule 5.1d shall be filed in the Constitutional Court. So then the question is, what does Rule 5.1d of these human rights enforcement rules say? Rule 5.1d basically provides for the different provisions or the different cases that you can bring under the human rights enforcement rules. And it's basically the same issues that we have been seeing, or the same nature of cases we have been seeing that the law has been providing for. And when you look at 5D, it says that an action that is brought in public interest is essentially something that has to be filed before the Constitutional Court. And an action for public interest really, again, it can be anything. So Rule 5.2 then goes on to, makes an attempt to explain circumstances when you can bring an action in public interest. And those circumstances are where there has been an infringement of a fundamental human right granted under Chapter 4, which I mean, this is something that can fall under enforcement under Article 50. And you have to go to High Court and non-constitutional court, right? Then Rule 5.2b talks about if a matter is of public importance and promotes human rights, democracy, and rule of law. And it also says that public interest action may also constitute any question as to the interpretation of the Constitution. So you see that Rule 5.2c is quite clear in terms of jurisdiction of the Constitutional Court. That is fine. Yes, we agree an action that requires interpretation of the Constitution can also be in public interest. But in the same vein, an action which does not necessarily raise a legitimate question as to the interpretation of the Constitution will also be a public interest matter. So that brings us to the challenge that this Rule 7.2 of the human rights enforcement rules has presented to us. We are saying that because of Rule 7.2, the Constitutional Court, as seen, for instance, in the case of Aleno George Williams versus the Chief Registrar of the Courts of Judicature and two others, which is a decision that was made in February 2022. The court reiterated the position in Attorney General versus David Tinyefuza and also the Ismail Serugo case, which is that only in circumstances where there is a legitimate question that requires the Constitution to be interpreted will cases be entertained by the Constitutional Court. This is a case where the petitioner was challenging basically the failure to have him given a practicing certificate and saying that it was a violation of his right to practice his profession. And the Constitutional Court said, well, you're simply challenging actions that have been done by an administrative authority, and this is something that you should be able to get redress for in the High Court. It is not something that is presenting an issue for constitutional interpretation. On the flip side, so of course, ideally, you would say this is someone that should go to the High Court, which is quite clear. You're simply saying, person X has done something to me, and they are acting or in their capacity as agents of the state, so I'm going to enforce my rights. And it's important to note, before we look at the flip side of what is happening in the High Court, that in this case, the petitioner's lawyer actually pointed out that, well, Article 137, 3b, that we saw earlier, actually says that if anyone feels that any act or omission of anyone in authority has violated the Constitution, then they can bring a suit before the Constitutional Court. But the court rejected that argument and said, no, this is a case that belongs to the High Court. And that is something that I think has been the practice ever since the decision in General Tinyefuza and Ismail Serugo. However, what is happening in the High Court at the moment is that unless you are bringing the case directly as someone who has experienced the violation, then the court is going to interpret your case as one that is being brought in public interest and as one that should therefore be determined by the Constitutional Court. And this is all because of Rule 7.2 of the Human Rights Enforcement Rules. A case in point is the recent case of Legal Brains Trust, which brought a case in the public interest, highlighting the fact that the decision of government to authorize a company to operate as a monopoly in a business that is related to transportation of petroleum products leads to violation of various human rights of the people of the Republic of Uganda. And the court said that in light of Rule 7, of course, first of all, the court felt that there was no legitimate public interest, but they went on to note, Justice Musa Sekana went on to note that even though there was a legitimate public interest issue that was presented by this case, it would still be a case that is supposed to be determined by the Constitutional Court by virtue of Rule 7D. It's important to note, please, again, that even before the Constitutional Court, if we approach the court without, the trend has been that when we approach the court without having a particular law that we are challenging, and for this I will just allude to one of the cases that we are working on or that we participated in with one of our partners, where they sought to challenge the failure of government to or failure of parliament to enact a law that operationalizes Article 22.2 on the right to life, specifically that exception on that provision that says that nobody shall terminate the life of an unborn child save in circumstances which may be provided for by an act of parliament. So the question has been, because for those of us who work in the public health and sexual reproductive health rights field, we are aware of issues that have to do with high-risk pregnancies, where you may be required to terminate the pregnancy in order to save the mother of the child, cases that have to do with pregnancies arising out of incest, rape, and so on and so forth. So that has been a major issue, and that is why one of our partners, SEHAD, went to court to challenge the failure or the omission of parliament to pass a law. Whereas I may not be able to comment to the full extent of what we think should or shouldn't be a final decision on that, one of the issues that arose during oral highlights, or the questions that were raised by the court, was the competence of the suit, given that there was no particular provision of the law that had been presented to court as something that needed to be interpreted as against the Constitution. So basically the argument of the question of the court was, is this case competently before this court as the Constitutional Court? To put in place a law that recognizes people in cohabiting relationships. We didn't just go to court as FIDA. We had to get a woman who has, faced the brunt of the failure of the state to put in place a law that protects her and put her at the forefront. And of course, we also came in as FIDA to also show the court the experiences we are having with other women as well in similar situations. That is how we are going about it. Then in terms of the longer term strategies, of course, we're trying to engage the rules committee that passed these rules on that particular Rule 7, because truth be told, the effect that it's having now is that it is actually, it's actually putting, it's blocking public interest litigation, to be honest, because if I can't go, I can't be here, neither there, then it means that, if I come as someone who has an issue that is in public interest, but doesn't necessarily present a legitimate issue for constitutional interpretation, I am going to be thrown out by the High Court, and then even the Constitutional Court will also most likely say they don't have jurisdiction to hear my case. So it's really causing an issue in terms of access to justice. And we are trying to engage the Rules Committee under the leadership of the Network of Public Interest Litigation Lawyers. And then, of course, the final point of action or resort will be to institute a suit, which will be quite interesting. But yeah, will be to institute a suit challenging that particular rule, of course, highlighting issues pertaining to do with the right to access to justice, especially given that it is a rule that is impacting on that right. Thank you very much. I hope I have utilized my time effectively. And yeah, thank you.
Okay, a round of applause for Susan. Indeed, you have utilized your time effectively. Although some were saying this woman is standing between our lunch. But thank you, Susan, for giving us the domestic perspective of forum. And colleagues, lunch is now served. However, since we started late, we are 30 minutes behind schedule. So I'm going to request that we break off for a 30-minute lunch. Is that possible? I pray it is possible. Such that we have time for an interesting afternoon session. In the afternoon, one of the first presentations we have is on choice of forum, and we shall be showcasing the African Court. For those of you who may not know, the African Court has a legal aid clinic that provides opportunities for advocates who are interested in offering pro bono services to clients who often go to the court. So if you're interested in knowing more about how this legal aid clinic works, how the African Court operates, please join us this afternoon at exactly 2 p.m. for this discussion. We have Mr. Victor Lowila from the African Court. He'll be sharing with us how the African Court operates. The lunch coupons are with Achilles. He'll be giving them at the back as we move out. The lunch is served at Kazinga. It's just at the basement. So you don't have to move out of the building. So we'll see you at 2 p.m. East African time. Bon appetit.
President, Honorable Lady Justice Imani Diabut, and from our registrar, Dr. Robert Eno Unde. I'm happy to be here with you, and I have really enjoyed the morning sessions, and it was good to hear from the other presenters about PIL, because I've been involved in PIL and in the regional system for at least 10 years now. First starting with the African Commission, and then I joined the court as a legal officer 5 years ago. I'm going to just give a brief introduction because my presentation originally was to cover the African human rights system broadly, which includes the African Commission on Human and People's Rights, which was set up. It was the first body to be set up following the adoption of the African Charter on Human and People's Rights, and it has both a protection and a promotional mandate. And then the African Committee of Experts on the Rights and Welfare of the Child, which focuses exclusively on children's rights. And then the African Court, of course, on Human and People's Rights, which complements the protective mandate of the African Commission on Human and People's Rights. So originally I had planned to talk about the seizure, jurisdiction, admissibility, merits and reparations, and then the monitoring and reporting systems on compliance, but I think I will not be able to do that. I'll just be touching on a few things here and there. Just to say, when you're focusing on choice of forum, for example, we also have in the global system the UN Human Rights Committee, and we also have the other UN human rights bodies, the treaty bodies for CEDAW, for the Committee on Torture, and so on and so forth. So there are very many avenues that you can pursue when you want to seek justice for human rights. In Africa is when we have people's rights as well. So in that regard, I just wanted to say that when it comes to the jurisdiction of the court is on alleged violations of human and people's rights for treaties that have been ratified by that respondent state, and in terms of any other treaties of human rights form. So you'll find that the African Court on Human and People's Rights has basically the widest jurisdiction of all the international courts, because the European Court focuses on the European Convention, the Inter-American Court on the Inter-American Convention, but the African Court, under Article 3 of the protocol of the that establishes the court, they have jurisdiction actually for treaties other than the African Charter that have been ratified by the respondent state. And this has led to a lot of debates in academia as to now if the African Court is interpreting the ICCPR, that is the International Convention on Civil and Political Rights, which is a UN charter. Will there be conflict? And is the African Court losing its Africanness in that regard? But I can assure you, the African Court was set up with an African mentality to cover African values. So even in interpretation of other treaties, the court always has that Africanness in the back of its mind, whatever the Africanness means. In terms of the African Commission on Human and People's Rights, its jurisdiction is actually based on the Charter. It's given the power and the mandate by the African Charter on Human and People's Rights, so it concentrates on the Charter rights. As for the African Committee on the Rights and Welfare of the Child, it actually concentrates also on the African Charter on the Rights and Welfare of the Child. So it's the Children's Charter. And when you are seizing this committee, it focuses on children, of course, that is 18 and below. But if a child, for example, seizes that committee and the case continues till past 18, the committee will continue to be seized with that case until it's done. Now, when it comes to other forms of jurisdiction, so the court actually looks at 4 types of jurisdiction. The personal jurisdiction is the first one, and it deals with who can sue and who can be sued at the African Court. So the member states who can be brought to the African Court, the respondent states, are the states that have ratified the Charter, have ratified the African Court's protocol, which are now 34 in number currently. Uganda is one of them, Kenya is one of them. I think those are Rwanda is another one when it comes to the East African countries, which means that in the African Union, where we have 55 member states, in the African Union we consider also Sahrawi Democratic Republic as one of the states, so we have 55 and not 54. It means that 21 countries have basically said they do not recognize the jurisdiction of the African Court. Now, in terms of individuals and NGOs, because if you're doing public interest litigation, it will involve individuals and NGOs, you have to have another form of acceptance of the jurisdiction of the court for you to seize the court. And that is through what is called a declaration. So a member state to the protocol has to file a declaration with the African Union Commission accepting competence of the court to receive cases from NGOs and individuals. And unfortunately, only 8 countries currently have done that. Uganda and Kenya are not among the members. But then there is another form of seizing of the court, and that is through the African Commission on Human and People's Rights. So Article 5 of the Protocol of the Court recognizes that if an individual of NGO, they want to come to the court, they can go through the African Commission. And this has already happened. The African Commission has seized the court against 2 countries. One is Libya, and the second one is the famous case against Kenya. I think you know it, the Ogiek case. I don't know if you know it. How many people know the Ogiek case against Kenya, the African Commission against Kenya? It would seem only Kenyans know. Oh, okay, there's another one. So yeah, this was a well-publicized case, and the judgment on reparations was delivered last year, and so now we are at the point of monitoring the implementation of that judgment. So when it comes to public interest litigation, you have to be innovative. I think one of the things that the morning speaker said, what is his name? He's called Dr. Robert, eh? He's called Dr. Robert, I think. He mentioned that when one of the strategies they use is that they put some of the most ridiculous remedies that they're requesting for at the start, like the first 2, and then the one that they really want it, they put it at number 3 and 4 and 5. So when it comes to the court, we have this famous lawyer from Nigeria. I don't know if you know him. He's called Femi Falana. You know him? He's a senior counsel, well respected, and he is excellent, I tell you. There is a case that was he brought before the court. It's called Bernard Mona versus Benin and 7 others. So basically, the case that was brought in this regard was a case that was alleging the violation of rights of the Sahrawi people due to the fact that Morocco are illegally occupying, the occupation of Morocco. Morocco are illegally occupying their country, but this case was filed by a Ghanaian, and it was filed against Benin, it was filed against Tanzania, and other countries. So when you look at this case on the face of it, prima facie, it looks quite ridiculous. Because, for example, if someone from South Africa claims that, for example, the rights of northern Ugandans are being violated by Uganda, and you cannot see any nexus at all. First of all, in this case, you could not see any nexus between the person claiming. Although in the African court, we do not have the issue of victimhood. You do not have to be a victim of human rights violations to seize the court. You can seize the court alleging human rights. That is enough. Yourself, you need not have to be affected with that alleged violation. So it sounded ridiculous that someone from Ghana is alleging the violation of the rights of people of Western Sahrawi in Morocco, and the case is being brought against the Republic of Ghana, against the Republic of Benin, claiming that they have something to do with it. It doesn't seem like there's any, what is it called in tort? Remoteness of damages, causality, causation. It would not seem so. But in this case, actually, because as you would imagine, the respondent states here would challenge everything. They would challenge the jurisdiction in terms of the material jurisdiction. First of all, the respondent state says this is a political issue, it's not a human rights issue, so you don't have material jurisdiction. The second thing they challenged is actually the territorial jurisdiction. They say this thing is not happening in our territory. Me as a Tanzanian, me as a Ghanaian, this thing that is happening, it's happening in Sahrawi and Morocco. That territory, whether it is Sahrawi or Morocco, that's a political issue. And then it is not happening in our country. So how can we be brought before the court? But what the court found, and it's what the other speaker in the morning was talking about, the sources of law. There is customary international, there is something called erga omnes. So what the court said, which was very interesting in terms of territorial jurisdiction, and in terms, and more especially in terms of extraterritorial jurisdiction, whereby the violations are not happening within the borders of your country. This is what the court said, that the obligation of states extends beyond their national territories and apply extraterritorially towards other people when it comes to the right to self-determination. So the right to self-determination is considered that it cannot be contained in one country. So for example, if there's a situation where northern Ugandans, or, okay, not northern Ugandans, I just wanted to say that because of we're in Uganda. Let's say the people of the so-called Ambazonia, quote unquote, right? The English-speaking side of Cameroon, and they are saying that they want to, they are not part of Cameroon, and they want to exercise their right to self-determination. International law recognizes that that alleged violation, if there is such an alleged violation, will go beyond the boundaries of Cameroon, which means that other countries in Africa, for example, have the duty to make sure that they intervene in whatever way. It has not been expressed in what way, but to secure the rights of those people who are seeking the right to self-determination. This was, it was an invention, both by the applicant and by the court, and time will tell whether this particular invention will work, how we go forward, and it will depend. There's a lot of discussion in academia now, so it's a very interesting case for you to read. It's called Bernard Mona versus Benin and 7 others. You can go and look at it. It's in the website of the African Court. Now, other than jurisdiction, there is another requirement for seizing the court, and that is admissibility requirements. So the African Charter on Human and People's Rights indicates seven things that must be met for the court to be seized, or for the court to exercise jurisdiction in that case. So those, the 7 things that must be done when it comes to admissibility. Number 1, you must disclose your identity. So when you're filing the case, it must be clear that it is Victor versus so-and-so. It cannot just be, you cannot file it anonymously, although there's a caveat. You can request for anonymity. But when you request for anonymity, still you cannot be anonymous vis-a-vis the member state. So if the case is against Gambia, for example, if it is Victor versus the Gambia, the name must be there. But if I've been given anonymity, to the public, it can appear as ABC versus the Gambia. But when you send it to the respondent state, when the case is served on the respondent state, the name of the person who has filed the case must be displayed. To contrast this with the African Committee on the Rights and Welfare of the Children, when there is a request for anonymity in that forum, even the member state will not know the name of the child. And I think this is because children, of course, are more vulnerable, and so they are protected more. The second case is it must allege really human rights violations, so it must comply with the charter. The third issue is it must not contain disparaging or insulting language. There's a case that was filed at the commission by an NGO which was filing on behalf of Uhuru Kenyatta and Ruto against the Republic of Kenya. And in that case, the case was rejected by the commission because they said that the case displayed some terms that were disparaging to the state. So they said the issues, they were saying that the state was aiding and abetting the violation of rights. Just a minute, I will get to you. So they said that the complaint contained expressions such as sickening, charade, the respondent is part of the ploy, trample under rights, fishing expedition, demonization. So such terms were considered to be disparaging to the respondent state. But if you listen to the judgment of the Supreme Court of Kenya in the case, the election petition that was filed recently, you will find that they had some choice words for counsel, which was very interesting. Huh? Yes, the fourth thing is that they should not be, the case that you file at the court should not be based exclusively on media. So you cannot come and bring a case that your only evidence is media, is from the media. So maybe you're quoting an article, or it is from a news article. That will not be allowed. It must be based on more than just that. Then the three last are very important. The first one is local remedies must be exhausted. So whichever country that you're filing against, you must have exhausted the local remedies. You must have gone to the highest court of that land. Or if the local remedies are not available, then you must state that they are not available, and you must show evidence that they are not available. Or if for example, someone has already attempted to file such case, and maybe the court does not have jurisdiction, the local courts that do not have jurisdiction to handle that matter. And one of the cases is like this one for Bernard Mona, whereby the local courts, obviously in Tanzania, in Ghana, they do not have the jurisdiction to look at the alleged violations in Western Sahrawi. So in such a situation, they came and they said, well, the local courts do not have jurisdiction, so you don't have to exhaust local remedies. The second thing is it must be filed within reasonable time. Now, reasonable time by the court is very relative. You just have to come and prove and to show why you seize the court at a particular time. There is no fixed duration like there's East African Court of Justice, where you have to seize the court within 60 days. In the African Court on Human and People's Rights, you can come and justify. Whichever time, you just have to come and justify and show proof. For example, if you come after 2 years, you have to explain why you did not come within a certain time. And now the last one, which now really goes into the heart of the choice of forum, is that Article 56(7) of the Charter says that you should not file a case in the court if it has already been decided on the merits in another forum. And this is why I said, if you go, for example, to the Human Rights Committee and allege violations, and if they find on the merits, either way, whether they find violations or not, you cannot come to the African Court and then claim the same violations, because then you'll be bad. It's similar to what is res judicata in the national courts. So in this regard, you have to, the court looks at three things to decide whether the matter at hand has been settled. The first one, it looks at the identity of the parties, but when it looks at the identity of the parties, it must not be exactly the same. So for example, we have a case that was decided recently. It's called TK Mwambipile versus Tanzania, whereby it was a public interest litigation case, and it was filed challenging the decision by the government of Tanzania to bar pregnant girls from going to school. The same case was also had already been filed at the committee, African Committee of Experts on the Rights and Welfare of the Child. The similar case with the same subject matter had been filed also at the East African Court of Justice. So you have three courts dealing with a similar matter, but if you see the names of the applicants, they were different. But what the court has said is that it doesn't have to be the exact same applicants, but there must be a proxy. There must be, it must be people who are claiming the same interest, especially in public interest litigation cases. And so, like in the case of TK Mwambipile versus Tanzania, the court found that another decision had already been delivered by the Committee of Experts on the Rights and Welfare of the Child in the case of Legal and Human Rights Center versus Tanzania. And so it found that the court did not find it admissible to again deliberate on the same issues that were already presented. Now, I wanted to say also that in the court we have interlocutory applications, just like in the domestic courts. So we have these provisional measures that you can apply for. And if you request for provisional measures, you must prove that it is a situation of extreme gravity and urgency, and it is necessary to avoid irreparable harm. And the court has found, like, especially whereby someone is on death row and they've brought a case in the court, and so you are trying to stop the member state, or the respondent state rather, from executing that person. The court has found that that is a situation of extreme urgency and it is necessary to avoid irreparable harm. I think lastly, I'm going to talk about legal aid at the court. Oh yeah, sorry, the court also issues advisory opinions on issues of human rights. So Pan-African Lawyers Union have been known to apply to the court, and the court has issued advisory opinions before. Now, when it comes to legal aid, I wanted to note that the court has a legal aid scheme in place, and we have a roster of advocates who can file cases against indigent applicants, and this is done pro bono under the court's legal aid scheme. And then we just have some small amount for incidentals. I know you are very rich lawyers and you charge a lot of fees in your cases, but we do have a small amount to the tune of $2,000 which is given for incidental costs for transport and to go and meet the clients, for the lawyers who are in our roster. And we have the applications to join the court's legal aid scheme, or the roster of the lawyers is on a rotational basis, so you can apply anytime. The form for application is on our website, and you just need to be a lawyer who has practiced for 5 years, an advocate who has practiced for 5 years. You prove that you are an advocate of any of the African Union member states, then you can apply for registration in that roster. Yes, so finally, I wanted to finish with a quote. This is a quote from a missionary, a Christian missionary, who was speaking about the missionary. And as someone does public interest litigation, you are someone who is you're on a mission. So what he said is that the romance of a missionary is often made up of monotony and drudgery. There often is no glamour in it. It doesn't stir a man's spirit or blood. So don't come out to be a missionary as an experiment. It is useless and dangerous. It's the same as regards to public interest litigation. As long as, unless your heart is in it, it is a long process, it is frustrating, and you can be targeted. You have to put your heart in it. That is it about the court, and very briefly about the African human rights system. Thank you very much.
Thank you so much, Mr. Lowila, for your presentation. Colleagues, since we started this session in the morning, we've not had an opportunity to receive questions on the various topics that were discussed. Now, I know some of the speakers are not around, but in particular regard to Mr. Lowila's presentation, I would like to know whether there are any questions regarding the African Court as a choice of forum. If there is any, we'll be happy to take 2 or 3 questions, and then we proceed with the subsequent speakers. So do we have any questions for the speaker? Or Mr. Ogada is also here. He made a presentation with Professor. I don't know why I skipped. So if you have any questions, they are much welcome. Yes, I see a hand from the host himself.
Well, this is a question for the experts on ESCJ and the African Court. It's very easy. Why would I go to the African Court rather than the ESCJ and the vice versa? What attractions are there in the 2 courts? Or rather, let me rephrase. Why should I not go to a court in Uganda and choose to go to the East African Court of Justice or the African Court?
That's question number one. What are the benefits of this court? Why should we choose them as a forum for our different matters? I see a hand at the extreme end. There's a lady. Simon, could you help me? Thank you.
Thank you. I have a question in respect to the East African Human Rights Bill. My name is Bibian, and I'm doing some research. It's my NLM research on derogations and limitations regime. And whereas it's very clear under the international law, under ICCPR, Article 4, and of course, the African Charter has a confusing position. But I want to know about the East African Human Rights Bill. How far is it? Has it been totally shelved? Are we trying to be proactive to get it enacted? And then the exhaustion of local remedies. To what extent do you take into consideration the exhaustion of local remedies before a matter is entertained?
Okay, thank you. I am sure our speakers have taken note of that. The third and last question, if any? Or should I choose? Okay, so I'll pass it on to Mr. Lowila first, and then we'll have Mr. Gada come and clarify some of the questions that are put to him. Okay, thank you.
I was going to defer to my senior, but since this is Africa, but okay. I've been asked by David, why would you go to the African court rather than maybe file your case at the local level or at the East African Court of Justice? So the African court, it is assumed has continental jurisdiction, so to speak, right? So we have not managed to really utilize that jurisdiction. And what I wanted to say actually is that the African Union as a whole is undergoing reforms. The African Union as a whole is undergoing reforms and when in the process of reforms, we are trying to secure universal jurisdiction over African countries, just like the European court have now universal jurisdiction because, well, except Russia now because of the war, now they are no longer part of the European court. But as at last year, the European Court on Human Rights had universal jurisdiction. So because of the kind of jurisdiction that the reach that the African court has, this is why you would file a case in the African court. I understand also national courts like the South African Constitutional Court, for example, the case of Makwanyane on the death penalty. It has gone really far and wide, and it has influenced policies, and it has a good impact. But also the African court cases has several impacts. So for example, even if you cannot attribute it directly to the cases in the African court, we've had cases whereby when applicants have seized the court, and when then we have served their case on the respondent state, action has been undertaken. So someone who was waiting for judgments to file an appeal has been called for an appeal when he had waited for so long. You find that cases which had stalled in the national courts, action has been undertaken after they seized the African court. So because of the kind of jurisdiction that the African court exercises, and the impact is wider than, for example, in the national courts, even with the understanding that now, with the cross-fertilization, national courts also influence each other in a greater way. And Julian, I think Julian asked a question to Senior Counsel Ogada here regarding exhaustion of local remedies, but I'm going to answer it as well in terms of the African court. So when it comes to the African court, as long as the local remedies are available, they are sufficient and they are effective. So available means that you can go to, for example, here in Uganda, if you have an issue on the right to privacy, you can go to the Constitutional Court in Uganda and you can get a decision in that there's a possibility of seizing the Constitutional Court on that issue. And then available, effective, can it be able to bring you a remedy once they've decided on it? So the other thing is it should not be unduly prolonged. So can it sort your issue in a certain period of time which can be considered reasonable? But the exhaustion of legal remedies is such an important issue, and that is one of the reasons actually that the United Republic of Tanzania stated when they withdrew the acceptance of the declaration to allow individuals to seize the court directly. They withdrew their declaration. Before that, prior to 2020, actually because it came into effect in 2021, prior to that, citizens of Tanzania could file cases directly before the African court, but now they cannot because the country withdrew that declaration because they said that the exhaustion of local remedies was not being respected by the African court. So it is a very key issue in the African court where we take it seriously and we look at case by case and we make sure that the applicant coming before the African court has indeed exhausted local remedies. Thank you for the questions.
I always keep it short. The East African bill, I think it's still in the pipeline. The last time I checked, it was still in the pipeline. I have not seen any conclusive efforts towards it being accepted. So I'll check. Let me not pretend to know more than I have stated. Why would I go to the East African court and not to the the African court jurisdiction? Like my brother previously speaking has said, the African court is exclusively a human rights court, and it will deal with violation of human rights questions. For the EAC, we have multiple jurisdictions, principles of the EAC, human rights jurisdiction under Article 27, the various aspects of people movement, goods, tariff. So you have to look at what question is before you determine what court to go to. I can detect a question. Which court will you go to in terms of human rights? When human rights violation has happened, do I go to the East African court or do I go to the African court? Look at your timelines. If your timelines are beyond the 60 days and you cannot go to the ESCJ is very rigid in terms of timelines. We have some case decision we were looking at with Professor Sepembwa some times back. You will not be heard at the ESCJ, so you're profitable to go to the African court. So it's a jurisdictional question. Look at what you're dealing with, the subject matter, the timelines, decide where to go. Did I answer all the questions? I hope so. Thank you very much.
Thank you, Mr. Lowila and Mr. Ogada, for responding to those questions. Now I will invite Naomi to come and take on the next session on risks, security, and mitigation measures.
Thank you so much. I'd like to introduce our next speaker. Our speaker has been the managing partner of Lukwago and Company Advocates since 1998. He is a seasoned Ugandan lawyer and a politician. In 2006, he was elected to the Ugandan Parliament on a Democratic Party ticket, representing the Central Kampala constituency. While in Parliament, he served on the Legal and Parliamentary Affairs Committee and on the Local Government Accounts Committee. In 2011, he was first elected to the position of Lord Mayor of Kampala City. And in 2016, he was re-elected, and then again in 2021, he again was re-elected as the Lord Mayor of Kampala City. Ladies and gentlemen, I request that we all stand up as we welcome the next speaker, the Lord Mayor of Kampala City, His Worship Arias Lukwago.
Thank you. Let's resume our seats. I salute you all, the leadership of the East Africa Law Society, Uganda Law Society, all of you distinguished participants. She has been elaborate enough about my brief CV. I thought she was going to indicate that in 2026, again, I'm going to be re-elected. But I needed to note again that while in Parliament, 2006-2011, I served as the Shadow Attorney General. You know, when you're in the shadow, you're hardly seen. But I served during that time in that capacity, leading the opposition on the legal front before Parliament. On another occasion, we shall discuss that. But I thank you for your kind attention to me and the invitation you extended to share my thoughts about this very important subject. Indeed, it's just about sharing my thoughts and probably a little bit of experience, because I just don't want to blow my own trumpet. I've been in the thick of it when it comes to public interest litigation. But you'll bear with me, I did some modification in the subject because there are certain aspects I didn't want to tackle, like security measures. I think I would be doing a disservice to myself and to you if I concentrated so much on the security measures. But I wanted to basically interrogate this doctrine of public investigation, how it has evolved and the challenges we have encountered in pursuing justice through public interest litigation, which I thought is very, very crucial, and we need to critically reflect on it. So my presentation will basically focus on those challenges. And you'll bear with me, I just have a simple slide here. Those of you who can follow. I will start with the textual exegesis of the doctrine of public interest litigation. I know, being lawyers, you are familiar with that very term, but there are a few things that we really need to put into context. The basic one, which you always refer to as lawyers, you know, your mind always goes to the Black's Law Dictionary. And they define public interest litigation as a legal practice that advances social justice or other causes for the public good. That is public interest litigation as defined. That is legal practice that advances social justice. I underline social justice or other causes for the public good. The decision of Bandura Mukuti Mocha versus Union of India, it's an Indian case. Public interest litigation was expounded to mean litigation not in the nature of adversary litigation, but it is a challenge and an opportunity to the government and its officers to make basic human rights meaningful to the deprived and vulnerable sections of the community, and to assure them social and economic justice, which is the signature tune of the constitution, of their constitution in India, but it's the signature tune of the constitution. So this is the essence of public interest litigation, which was expounded on in that particular decision, which is quite fundamental. What it is significance. It's not, and this is actually where the problem starts from. It is seen as an adversarial contest between the litigants and the state. It's not all about that. It's a mechanism designed to offer an opportunity to both the citizens and the government to confine themselves within the framework and parameters of the Constitution and respect everybody's rights. Hence, the element of social justice. In our case, public interest litigation, the foundation of public interest litigation is to be found in the Constitution. At your leisure time, you read the provisions of Article 3, Clause 4 of the Constitution. It gives the foundation for public interest litigation by making it a duty of all citizens to fight any form of unconstitutional tendency, using whatever means available. And for you, the lawyer, the tools you have is the law and the process of litigation. So you should be vanguard in that. You also look at Article 8A, Article 50. Article 50 brought some innovation in the area of human rights. You don't need to have locus standi to fight for one's rights, to file a case in court. No. You know, this traditional justice system provides for that doctrine of locus standi. In any case you bring, and those litigious lawyers on the other side will always look at the matter you bring before court. Does it disclose a cause of action? Does this man have locus, and so on and so forth? You don't need to go into that. I think this is quite laudable. It's a new innovation in the area of our constitutional jurisprudence, and we need to make use of it. Article 50. So be concerned about violation of rights. So anyone, if you feel not aggrieved, if you are just concerned, please. Article 137 is well known to you about constitutional matters and other relevant provisions. So the bottom line here is about grounding the doctrine of public interest litigation in our Constitution. Again, you'll find Professor Roca attempted again to digest it further. In his book, When Courts Do Politics, Public Interest Law and Litigation in East Africa. It's a very interesting book. I'd like to interest you in it so that you can broaden your knowledge about this whole concept of public interest litigation. Briefly, this is what he says, that public interest litigation refers to court action that seeks to secure the human and constitutional rights of a significantly disadvantaged or marginalized individual or group. Significantly marginalized. So it tends to focus on that group or individuals who are significantly marginalized. It's a mechanism that has been utilized to challenge legislation, arbitrary state action, or even violations by private individuals that have public implications, such as ethnic or gender-based discrimination. Such legal action can be used in tandem with the broader social and political environments directed at change or to encourage alliances that result in political action. I'll be referring so much to Professor Loka because his thesis, rather treatise on this, is a locus classicus. I'm sure you know Philip Karugaba, one of the senior lawyers we have in this country. He also wrote a paper, a very good paper, titled Public Interest Litigation in Uganda, and he traces public interest litigation in the biblical gospel. For him, he goes beyond the Constitution and he goes to the Bible. In Proverbs 31:8-9, there is this command: speak up for those who cannot speak for themselves, for the rights of all who are destitute. Speak up and judge fairly. Defend the rights of the poor and the needy. That's a biblical command. It is also reflected in Psalms 82:3-4. Defend the poor and the fatherless. Do justice to the poor and afflicted and needy. Deliver the poor and needy. Free them from the hand of the wicked. If I might pause and throw the challenge to you, how often do you help to rescue some of us who may find ourselves in the hand of the wicked? How often do you rise to the occasion? Or you simply say, Zirinda Bolwange. We have that saying in my language, Zirinda Bolwange. Tawa musibe mmere. Public interest litigation, you wish to understand, is a tool for social change. You must understand this. Public interest litigation is a tool for social change. You read about the literature from the Indian jurisprudence. It's the best, I think, the best model. If you are interested in public interest litigation, read so much about litigation in India, Pakistan, Belize, South Africa, and of recent Kenya. They have also made some inroads in that. Bangladesh and a couple of other jurisdictions. Professor Okonyango, in his aforesaid book, mentioned this is subject to debate, but he credited the emergence of this doctrine, the practice in this area in the post-independence East Africa to three individuals, picking one from each and every country, the three countries which constituted East Africa then. Right now, the family is becoming big and big every other day. Professor Loka recognized Abu Mayanja in Uganda as one of the progenitors, the forefathers of public interest litigation in Uganda. Oki Oko Ombaka from Kenya, and Isa Shivuji of Kenya. Tanzania. I remember when I was a law student, you would also wish to know Secretary General Makerere Law Society. We traveled all the way to Dar es Salaam University and met Isa Shivuji. It's one of those celebrated academics. In a nutshell, as I sum up the overview of this particular doctrine so that we get to understand it, you need to focus on two key elements when you are looking at public interest litigation: social justice or human rights, and constitutionalism. Anything outside that, it's not in the realm of public interest litigation. The challenges is what I'm going to focus on. That forms the main text. The remaining few minutes I have, I'll just concentrate on that, the challenges, and of course, inherently enshrined in that presentation, we find the mitigation measures. They are not specifically highlighted, but I alluded to the same in the course of the presentation. The first challenge is judicial activism vis-a-vis judicial restraint. There is a huge debate in any given jurisdiction. What direction should we take? Should we focus so much on judicial restraint or judicial activism? I invite the East Africa Law Society. I invite you, Uganda Law Society, Kenya, and elsewhere. Please, let us reignite the debate on this very thorny issue in as far as public interest litigation is concerned. If I had enough time, I would take you through our experience, those of us who have confronted it head on. It is really a very, very thorny issue. It's really disturbing. I say hot potato. But actually, it's the crux of the matter. It's truism to state that the cornerstone of public interest litigation is judicial activism. That is the bedrock of public interest litigation is judicial activism. Where there is no judicial activism, forget about public interest litigation. And this is where we are finding a problem. Countries that have been successful in public interest litigation, like India, they have been liberal, they have been innovative, revolutionary in their conduct of judicial matters. I'll quote for you again Oroko Nyango in his aforesaid writing. The power of interpretation of the Constitution is an inherently political activity. Nevertheless, in using that power, courts must decide whether to pursue a course known as judicial activism or hold themselves back in a posture of its opposite, otherwise known as judicial restraint. The antithesis of judicial activism is judicial restraint. This is now where my disappointment comes in. Unlike liberal polities like India, our justice system, and indeed jurisprudence, is still steeped in the old-fashioned mold anchored on judicial restraint as opposed to judicial activism. This may not be good news to you who have interest in venturing in this area of practice, public interest litigation. In an environment where you have judicial restraint as opposed to judicial activism, you have a problem, a very big one. I'll give you my example before I proceed here. We tried to interest our judiciary here in this doctrine. I don't know how many of you followed the famous age limit case in Imbali. I'll give you the citation here. We were challenging the constitutional amendment, and our main focus and attention was on the power of the Legislative Assembly to amend the Constitution. Is it limited or unlimited? It was a strong contention before the Constitutional Court. Is the power of Parliament to amend the Constitution limited or unlimited? Remember, that was public interest litigation. And it was two-pronged. Removing age limit for the qualification of the president and also extending the tenure of Parliament. And we demonstrated the absurdity of that decision Parliament had taken. The Constitution, Parliament itself is a creature of the Constitution. In terms of father-son relationship, the Parliament is a son of the Constitution. Now we ask the judicial courts of law, doesn't it sound ridiculous to say a son has got authority to change the structural framework of the father? Either Parliament itself doing it, or going through local council decisions, or a referendum. So if they follow those three routes, they can always amend the Constitution. We said no. There is the doctrine of basic structure. The doctrine of basic structure. That much as the Constitution provides for mechanisms of amending the Constitution and vests the power of amending the Constitution into Parliament turning itself into a constituent assembly, there are those inherent limitations that Parliament cannot change the nature of the Constitution to the extent that obliterates its identity. That is the whole essence of the doctrine of the basic structure doctrine. That there are pillars you can change. We also demonstrated it by showing like this structure here. The architects will tell you, you are free to change the partitioning, the what, but there are pillars that are holding this structure together that the moment you tamper with them, it crumbles on its weight. That's how constitutional law is constituted. And this doctrine was borrowed from. I will not bore you so much with that, but I just wanted to interest you in that doctrine of basic structure, which unfortunately has failed to make its way into our constitutional jurisprudence here. We tried it. Justice Kakuru, I must commend him. Those of you who have time, go and read his judgment. It's a huge one. Very interesting piece. Justice Kakuru, he gave a dissenting judgment. And for him, he said it should be embraced by our jurisprudence here, the justice system. And he explained it. We gave a comparative study, experiences of other countries' democracies, starting with a scholar who initiated it from Germany to the practice in India. Kenya here, they tried it. In Njoya case, I will give it to those who want a jurisdiction. Kenya, they rejected it in the decision of Mutikira. Reverend Christopher Mutikira, and a couple of others, but that is Tanzania rather, they rejected. But now, the point is, you have, the Supreme Court said no, save for only Justice Lilian Echirikubinzi. So now the danger we have, those of you who want to litigate on unconstitutional tendencies perpetrated by Parliament, you have a hard task. The moment they comply with the procedure, even if they change the texture of the Constitution, its features and whatnot, as long as they have complied with the procedure. Justice Kakuru posed a question in that judgment and said, wait a minute, these people have extended their tenure to 7 years from 5, when actually the electorate gave them 5 years. What will stop them from changing the Constitution to abolish the judiciary? Because they can follow the procedure of amending the Constitution, they go to a referendum, and the people say, we are now abolishing the judiciary. Is that acceptable? But that will be destroying the spirit of the Constitution. So we need this doctrine in our jurisprudence. That is my call. And I want to invite you to be crusaders for this doctrine. Crusaders. It pains us to see that it doesn't feature prominently in our debates. So we shall not make headway unless we have judicial activism in this country. In Attorney General versus all, this you'll find, you'll get the citation, it is there. A citizen whose constitutional rights are allegedly trampled upon must not be turned away from the court by procedural hiccups. Once a question is arguable, a way must be found to accommodate him so that other citizens become knowledgeable of their rights. Again, I'm going to the second issue. This authority is quite instructive about the applicability of Article 126 of our Constitution. It has been vulgarized. And this is the point I wanted to make here, that there is ambivalence and sluggish response to that new phenomena within our constitutional jurisprudence. There is that new phenomena which came with the new constitutional order of 1995, that due regard should not be given to undue regard shouldn't be given to technicalities. Now, when you appear before judges, what happens? Even in the cases of public interest litigation, they want you to strictly follow the procedure. If you are to come by originating summons, and you to access court by, say, originating summons, and use chamber summons, they say, no, go back. But whether it is originating summons or chamber summons, how many chambers are before you? Does it really matter? I'm already before you. There is a problem. There is an issue to be adjudicated upon. Now you are telling me, no, it should have been originating summons, no, but not chamber summons. These legal fictions which were initiated by colonialists. I'm aggrieved. My rights have been violated. Now you are telling me originating summons. We have a problem. I don't know whether you have read these acts of enforcement of rights which were made. The dichotomization of the jurisdiction. That certain rights you go to magistrate courts. There are those you right away go to. If it's violation of non-derogable rights, and you go to the magistrate courts, they will chase you away. They will dismiss your application that you are before wrong court. They say, no, non-derogable rights you have to go to. But what would stop a magistrate to handle? So these are things we really need to deal with. In public interest litigation, on matters of social justice, technicalities should be put aside. Even if I appear before a magistrate orally and I state my problem, it's your duty to reduce it into writing. Yes, where do you want me to put it? To write a notice of motion. And a notice of motion by nomenclature, it means I'm notifying you that I'm going to bring a motion. Notice of a motion. It's not a motion. You get it? Notice of motion is not a motion in itself. It's a notice that I intended to bring a motion. But why should I first give you notice that I intend to bring a motion? Let me bring a motion right away. So public interest litigation should not be strictly pegged on those procedural technicalities. Shouldn't. Especially on matters of social justice. With constitutionalism, fine. There could be procedures you have to follow to challenge. But with the enforcement of rights, that's why it should be as informed as possible. You appear before Uganda Human Rights Commission, you record the statement. You do this and that. Our judiciary ought to be more proactive in adjudicating matters of public interest as per the constitutional command enshrined in Article 34 of the Constitution. I promise that I will dwell so much on this, but in the interest of time, I'll just point out one thing here. You need to put this in proper context. Look at Article 34 and what it says, how important it is. Who has my constitution? Get me that constitution here. Article 3 rather, 4. All citizens of Uganda shall have the right and the duty at all times to defend this constitution and in particular to resist any person or group of persons seeking to overthrow the established constitutional order. B, to do all their power to restore this constitution after it has been suspended, overthrown, abrogated, or amended contrary to its provision. Any person or group of persons who, as required by clause 4 of this article, resist the suspension, overthrow, abrogation, or amendment of this constitution commits no offense. The operative word here, duty of all citizens to defend the constitution. So if I'm vigilant as Lukwago, a public interest litigant, I bring a matter regarding a violation of the constitution before court, what makes the bench believe that the duty is on me to defend that matter, and it's not you don't share it as a member of the bench? You get the point? That we all have the same obligation to defend the constitution. Myself, who has brought this matter before court, and you, the judge handling this matter, you also have that duty. Don't cast the burden of proof on me. Actually, the moment I bring the matter before the judge, we share the obligation now to look for the evidence. Yes, together, jointly. Why? Because you also have a duty under the constitution to defend the constitution. You conduct an inquiry now. Is what we are talking about true? The moment you are satisfied that there is a prima facie case in what Nkwago is saying, the burden should automatically shift to the Attorney General. Automatically. I've discharged my burden by making a prima facie case that is a matter worth investigating by court. Because this is not my document. Is this Nkwago's constitution? Now you make it my burden to look for money, to dig in my pocket, to do research, to do this, and spoon feed you as a judge who also has a constitutional duty. How are you discharging your duty? Then you have the audacity of telling me you have not proved your case. Yes, is it my case? Please, let us not treat public interest litigation matters as individual cases. Am I making sense? I don't know whether I'm making sense when I raise these matters. So these are some of the problems we have encountered, those of us who are involved in these matters. Now, Lilian Tebatema, Echiri Kubinza, in her paper, The Judicial and Enforcement of Human Rights, Between Judicial Activism and Judicial Restraint. It's a very good writing. You need to read it. Between judicial activism and judicial restraint. She states, she cited the case of Uganda versus Aruna Kanabi. And in this case, Aruna Kanabi was charged with the case of sedition. And the lawyers representing Aruna Kanabi cited the issues to do with the violation of the constitution. And he said, but this law of sedition, by that time it had not been declared null and void, is offensive to the constitution. That was there. And the magistrate was duty bound to say, wait a minute. If this law offends the constitution, let me invoke the provisions of Article 137 and forward it to the Constitutional Court for interpretation. Because there is that room provided. But you listen to what the magistrate said. This court is not a constitutional court. It therefore lacks capacity to interpret the provisions of the Constitution beyond their literal meaning. As such, I am of the view that where the state, having regard to its supreme law, keeps on its statutory books a law that makes it an offense to do a certain act and hence to limit the enjoyment of specific freedom, this court will accept that restriction as lawful and shall go ahead to punish any transgression of the same according to the existing law until such a time as the state deems it fit to limit such restriction after realizing that such restriction violates a certain right. In other words, the magistrate was alive to the fact that actually this particular provision of the penal code was offensive to the constitution. But said, as long as it's still on the statutory book, for me I will continue charging you, I will try you, until the state deems it proper to remove it. No, you have a duty. Under Article 3, and there is room given to you under Article 137 that please you stop all the proceedings and forward the matter to the Constitutional Court. So we need to pump this message to the judiciary so that they appreciate and keep and adjust, adapt to the new constitutional order. Finally, the number of examples which I can cite. The case of retired Dr. Chiza Besigye versus Attorney General, Constitutional Petition 33 of 2011. It's a very interesting one. It was also about violation of his rights and went to the Constitutional Court. And in some of the governments, he stated that he had won the elections, he was rigged, but he went ahead to swear himself in as the president of Uganda. But he was arrested, molested, persecuted, harassed, detained illegally and whatnot on that account. And they charged him with treason, which case they abandoned. Then, in the lead judgment, may his soul rest in eternal peace, Justice Kakuru Kenneth said the petitioner Dr. Chiza Besigye maybe he will have to seek audience before his own court or before the judge who saw him in as president. You can imagine. And since you claim that you saw yourself in as a president, go to your court. Then because you don't recognize these courts. But I'm a citizen. I have to enjoy those rights. So these are all challenges we are facing in public interest litigation. Don't lose focus of that particular point, where you have judicial restraint as opposed to judicial activism. That should reverberate all through the discussion. Judicial restraint, judicial activism. Then the second thing, because I don't have enough time, if you can also interest yourself in the Susan Chigula case, for example. Susan Chigula case, FHRI, we were all there in that case, Foundation for Human Rights and others, we challenged death penalty. And in principle, the judiciary agreed with us. We said, it should be a very familiar case with you. He said, the right to life is absolute. Why should the state take our one's life? Actually, death penalty is not a punishment. They agreed with us. And they said now, this provision in all penal laws, which provide that once you are convicted on a particular charge, thou shalt suffer death. The word suffer death was declared unconstitutional. He said, shall suffer death. And they said, all those who were on death row at that time, the death sentence should be commuted to life sentence. But strangely, they left the provisions which make it discretionary. To me, they even made it worse. That instead of one shall suffer death, they said the better phrase should be one is liable to death. Instead of making it a mandatory sentence, they are saying now it's discretionary. You're even making it worse now. You're putting my life at the discretion of an individual. Now it's the judge to say whether I should suffer death or not. Making it discretionary. When we're all prone to lapses, that is dangerous. So let us interest ourselves in all these matters. Then the next thing is a brigade or cowed judiciary. Listen to this from Philip Karugaba. The potential of public interest litigation to force issues that the government is unwilling to legislate or otherwise act upon will come to a naught if the judiciary is unwilling to take bold steps in this new direction. We need a bold and courageous judiciary to take the challenge of public interest litigation and through judicial activism give life and vitality to the Constitution. We need judicial creativity to bring new thinking to all the problems and seek new solutions. We also need judicial courage to follow on these new solutions to give full meaning to the Constitution. The courts should not plod on enforcing all the laws that do not stand the test of the Constitution. The laws of sedition, the Divorce Act, etc. are only some of the offending ones. I had to quote that excerpt for its significance and importance. And I invite you, members, particularly the leadership of East Africa Law Society, to look at it and guide us in changing the trajectory of our judiciary. The political turmoil and upheavals that have bedeviled this country since independence have no doubt had a chilling effect on the independence of the judiciary, particularly the gruesome murder of the first black Chief Justice, His Lordship Benedict Ochiwanuka, the Black Mamba invasions, etc. Again, I don't need to bore you with this. Those of us who are involved in public interest litigation, we have faced this head on. The chilling effect on the judiciary. It is going to take us ages, I'm telling you. I remember, I wouldn't want to mention whether it's the current Chief Justice or those who have since retired. I had a one-on-one with one of the Chief Justices. I found him and I was asking him about my case, which had delayed in the Supreme Court. My very case, where I was impeached. I got an interim order to stay the proceedings and to stay the actions of those who were throwing me out of the office of the Lord Mayor. Then the then acting Chief Justice had hidden himself in a wardrobe to write a ruling. My lawyers, Peter Walubiri, Katuntu, Segona, came and banged the door when he was writing the ruling. Then we had to rush to the Chief Justice to come to our rescue. Found him at his chambers. He listened to us. Then he made one statement which dampened my spirit. Said, my brother Rwaga, I sympathize with you. But do you know, this very office where I'm seated is where Benny Chwanka was picked from in broad daylight. It was at 9 a.m. And up to now, his remains are interred in a place which is not known. I just bowed before him and said, much obliged, my Lord. And left. So when I talk about a cowed judiciary, and we are talking about the challenges of public interest litigation, because public interest litigation is essentially against the state. The state is the biggest violator of people's rights. The state is the biggest violator of the Constitution. So you are confronting the head, the state, and the state is a monster. In whatever shape it manifests itself. So here you are, the man is telling you, oh, hey. So literally, what do you do if you were in my shoes? Like he asked me, if you were in this very chair, what would you do? Then I posed the question to you, what would you do if you were in my shoes, who are seeking from justice from a man who is saying, my friend, the events, the fate of Justice Ben Chwanka is still alive. So I invite you also to read a very good paper that was presented by Justice Wambuzi. Justice Wambuzi is still, Wako Wambuzi is still alive, is my good friend. We communicate quite often. So he presented a very good paper on the chilling effect of the Ben Chwanka. We were launching the Ben Chwanka Memorial Lecture at the High Court building. He has a lot to tell you, those who are involved or want to venture into public interest litigation. Again, I will refer you to the case, the very last one on this particular matter, then the rest I will just summarize. In the case of the Attorney General versus Pokawanga Semogere and another, Constitutional Appeal number 3 of 2004. I was still a small boy at that time. She told you I started practice in 1998. Yes, I enrolled on 18th November of 1998, and straight away with the colleagues we started a law firm. Don't ask me how we did that. But at that time, there were lots of things that were happening as far as constitutional is concerned. So I was enlisted on the team of lawyers to represent Dr. Pokaanga Semogere together with my seniors then, Professor Sempebwa, Lule and others. So this was one of the very interesting cases I wanted to share with you. And you have to read it. It's a very interesting decision. It was about challenging the constitutionality of the Referendum and Other Provisions Act of 2000. Referendum Political Systems Act of 2000. There is one they had passed, which we successfully nullified for want of quorum. Now they hurriedly brought another one, suspending a particular provision, doing this, and the bill was tabled at 2 p.m. By 3 p.m. they had already gone through all the processes and amended the constitution to bring this law. So they brought this law, Referendum Political Systems Act 2000, hurriedly to organize a referendum on political systems in 2000, whether Ugandans wanted to retain the movement political system or they wanted to go multi-party system. So we challenged that one as well. We went to the Constitutional Court, we succeeded. The Constitutional Court agreed with us and said the act was null and void. And therefore, the referendum, which had been held on the foundation of that particular legislation, was equally null and void. But you remember, now this is 2004, and they had held the referendum in 2000. Those of you who were old enough to participate in that process, where we had the DAV versus, the DAV represented the multi-party democracy, and then the BAS represented the movement political system. So essentially it was a constitutional command, and they had gone past that. So now it had collapsed. And they had held the elections of 2001 under the movement political system, which ostensibly had been chosen by the people of Uganda in the 2000 referendum. So now they had that legal conundrum. And to untangle it became a problem. So we got a judgment that declared the act null and void, and also the referendum, and the movement political system illegal. And therefore the government also illegal. Then the president asked them, if we are all illegal, then how is the judiciary itself spared from these illegalities? Because I'm the one who has appointed you and what not. So that's how they vulgarized this. Now when the matter came to the Supreme Court, they were in a catch-24 situation. This is what they said. As a consequence of the referendum, the movement political system was retained in place. And the affairs of the state have been conducted on that basis for over 4 years. To declare the referendum a nullity would have far-reaching consequences. In our view, these were compelling circumstances in respect of which the Constitutional Court ought to have exercised its discretion to decline granting the second declaration. There were two declarations. The act, null and void. The referendum, null and void. Now the Supreme Court said, no, the Constitutional Court, yes, they were right and justified in declaring the act null and void. But for fear of these consequences, they should have refrained from granting the prayers. Then we kept asking, and I'm still asking myself, would this judgment not be a nugatory judgment if I just get a declaration that the act null and void, and therefore a declaration is made in vain for the sake, and therefore we asked the Chief Justice then okay, substitute the order with any other remedy you would have given if you were in the Constitutional Court. Because they have no remedy. You are saying they should have restrained themselves and not granted that remedy. And therefore, help me also understand that. You have declared the act null and void. And now you go to remedies. Because after analyzing the law and making findings on matters of law, the next thing you go to remedies, what remedies are available. Then they are suggesting you go away with no remedy. This, I'm raising it, you'll find so many decisions of that nature, where you get declaratory judgments with no remedies. So it becomes litigation in vain. And that has characterized public interest litigation in this country. You need to take a note of that. It's also important to take a note of the melodrama that characterized the Supreme Court decision of Dr. Kizza Besigye versus General Yoweri Kaguta Museveni, as explained by one of the justices. The citation is there, Presidential Election Petition number 1 of 2006. I was also privileged to be part of the legal team, as explained by justices who handled the matter. Justice Kanyehamba, in his book titled The Blessings and Joy of Being Who You Are. I wish I had time. It's just one page, if I can share it with you. Allow me some more time, because this is the only time I have with you. Very interesting if you could listen to me. In this case, if you have not read this book, you spare some time, at least one page, we share it together. You get to understand how the judgment was changed at the 11th hour. The Blessings and Joy of Being Who You Are by George W. Kanyehamba. You need to get this book if you have not read it. On page 308 here, let me be very fast here, if you can follow. Following the conclusion of the hearing of that case or petition, I was among the justices who had doubts about allowing the petition. He was saying, no, I'm going to dismiss it. After hearing, I immediately expressed the view. No, I was among the justices who had doubts about allowing the petition, yes. I immediately expressed the view that the lead counsel for the petitioner had presented the case very poorly and had not convinced me that a good case had been made out for his client to succeed. I therefore initially indicated that, unless convinced otherwise by the evidence which we were to read thereafter, I was inclined to dismiss the petition. After several days, as panelists we discussed the case and our preliminary findings. I was still of the same view, which was shared by two others, with the other four indicating that they had not as yet made up their minds regarding the petition. A week later, a panelist, who is a close friend of mine from university days, called me late in the night and pointed out that history will never forgive us if we did not allow the petition and order the holding of another presidential election. He proceeded to enumerate a number of affidavits of witnesses and legal and judicial decisions he urged that I should read before confirming my opinion on the matter. I was bothered by his revelations and became restless. I had brought home copies of the proceedings, authorities cited by counsel, and other documents, including reports of impartial observers of the elections. Initially, I had browsed through them, but not seriously studied them because of my bias against the poor performance of the lead counsel for the petitioner, even though his junior had performed remarkably well and competently. I don't know whether the junior was myself, but he castigated the senior counsel who represented the petitioner. I woke up in the night and read the materials. That is after a fellow judge called him and advise them that history will not absolve them. I woke up in the night and read the materials my friend had identified for me. I did not complete reading them until around 3:30 a.m. I was amazed by what I found. My colleague, who made me aware of the importance of carefully perusing those documents and authorities, was correct. History would not look at us kindly if we dismissed Kizza petition. I changed my mind. On that note, at 3:30 a.m., Justice Kanyamba changed his mind. From that night until we delivered our findings, I firmly maintained the view that the petition should succeed. When we next had a straw poll, the result showed that 5 of us would allow the petition and 2 would dismiss it. It was going to be 5 allowing the petition, Kizza versus Museveni, 2 dismissing it. We agreed to go back and study the materials again and return within a few days to reconsider our findings. When we next met, one of our colleagues on the panel, whom we respect, asked us a number of questions. The first was that while he was still committed to allowing the petition, could the court or anyone else guarantee that in a repeated election, no such malpractices and breaches of the law we had found in the election could not occur again, or even increase in the election that would be held after publication of our findings and orders? Issue number 1. He further wished to know whether it was not possible that the army, which was now intensified with and controlled by the first responder, Yoweri Kaguta Museveni, might ignore our orders and instead stage a coup d'etat and military resistance. No, a coup d'etat and militarily reinstate its commander-in-chief and suspend the constitution. None of us could guarantee anything or give him assuring comfort. However, some of us pointed out that the spokespersons of the army had promised to honor the decision of the court, and the Electoral Commission had publicly declared that it was fully facilitated and ready to conduct a new election in the event that the Supreme Court ordered the nullification of the previous one. Our colleague was not satisfied with these assurances. He therefore informed us there and then that he had changed his mind. Now one had changed. He intimated that even though he was fully convinced that the presidential election was fraud, but for the sake of peace in the country, he would be dismissing the petition. His decision left those of us who still wanted to allow the petition with a majority, as against those who had made up their minds to dismiss it. Are we still together? At that stage now, initially there were 5-2. Now one has changed on that account that was fearing for a military coup. Now there were 4-3. The presiding officer was asked, that is the Chief Justice, the presiding officer was asked to prepare the court's collective decision that would show a split of 4-3 in favor of allowing the petition. And we fixed the date and the time of the delivery of our findings and orders. And I guess they closed the chapter and the hammer had fallen. We did not have another conference until the very day we were to reveal our decisions. Initially, the Chief Justice noted that as things stood at the time, we would be delivering a judgment in favor of the petitioner, Kizza Besigye, by 4-3 justices. I'm winding up. I know you're reminding me about time. But I wanted to share this, I'm completing it. The majority of the panelists decided that the court should not read its judgments in full, but a brief statement summarizing the court's findings would suffice. I indicated that on my part, I would read my judgment in full. I subsequently did. Just before we were about to rise and enter the courtroom, where we were scheduled to publicly reveal our findings and orders, the Chief Justice, as if by prior arrangement, stopped us and announced that it was essential that even at this last minute of our deliberations about the petition, he wanted to give everyone a last chance to reconsider their final position on the petition. He intimated that he would once more ask each panelist how they intended to vote when we entered the courtroom for the pronouncement of our findings. He asked each of us to individually say yes or no to allowing or dismissing the petition. While six of us maintained our opinions we had expressed the previous week, my friend, who had taken me the trouble to previously warn me in the middle of the night that I should allow the petition, he uttered the word that left most of us shocked. And that word was dismiss. The one who had cautioned him that history will not judge them rightly. Some of us could not believe our ears. I looked at him, but his eyes were looking down as if he were ashamed of what he had just said. I said nothing, but after a few moments, he addressed me in the hearing of everyone in the room and said, he quotes, "I am sorry, George." Now, George Kanyeham. "I am sorry, George, my friend. I took you down the garden path and left you there." I think I should stop there. Just read the book for yourself. And that's how things turned around. And today, things have not changed. Look at what happened to the case of Kyagulanyi. I've also made reference to it. Kyagulanyi versus Yoweri Kaguta. The very recent one, the altercation, how we got embarrassed as members of the legal profession and the country, Chief Justice and Justice Chisachi. Those bizarre incidents you have witnessed there. And mind you, I'm raising this because that's public interest litigation. I'll leave it at that. Let me proceed. Apparently, there is also failure of court to outright abolish the general court martial, notwithstanding their laudable decision. There are a number of cases. There are a number of cases which I would like you to read. The Constitutional Court has pronounced itself on the constitutionality of the general court martial. There is Joseph Tumusabe versus Attorney General, Kabaziguruka versus Attorney General, Uganda Law Society versus Attorney General, Dr. Chiza Besigye versus Attorney General. But things continue unabated. It's as if nothing has changed. And none of you can practice. Literally, you can't practice to defend people's rights in the general court martial. You cannot. You cannot. I am here. If I tell you it's a kangaroo court, I mean it, and I speak from my heart. I have the record of being a convict because of that particular court. I've never been convicted in any other court except for the general court martial. I am a convict before you. And I went to court, one thing which has lived in the infamy, which has lived on my record, that day when I entered the court as a lawyer to represent Dr. Chiza Besigye in 2005. In the morning, I entered as a lawyer. In the afternoon, I emerged out of the court as a convict. Before even my client was tried. And never mind that he was never actually, himself was never convicted. But myself was presented as a lawyer. Simply because the judge, it's even a misnomer to call the presiding officer as a judge. These are presiding officers. There is even a judge advocate, that judge advocate. Oh my God. It's terrible what goes on there. So we raised the procedural matters. And then the judge said, you were wiseacre. And he misconstrued even the word we had used. Because my colleague was Alaka Caleb. Caleb said, my lord, Mr. Chairman, it's unfortunate that we are being treated like this. We came here robbed. He didn't even wait for him to complete the statement. We came here robbed. He wanted to finish the statement by saying, robbed as lawyers, and we can't be treated as accused person. He said, you came here robbed? Who robbed you? Do you think, are you saying there are robbers in court here? You have not been robbed. The guy became furious. He was livid. He tried us in a space of just 1 hour and sentenced us to imprisonment for 2 weeks or a fine of 1,000 Uganda shillings. So we raised 1,000. Personally, I had protested. I said I will not raise it. Then Salam Musumba moved around with a basket, collected the coins of 50 shillings. By that time, they were still legal tender currencies. I don't know whether these days the coin of it. Anyway, that was the melodrama there. But it's your duty now to fight. Those of you who are interested in public interest litigation, human rights defenders, you pick it up from there. We handled the Kabaziguruka case. I was in Uganda Law Society case. We have gotten these judgments about the illegality of the general court martial, but it is still there. So you cannot appear there. It's risky. Risky for you to practice before the judge. And I caution you from that time, any instruction you bring me, I'm sure you have not seen me there as a lawyer. The next time I appeared there, against my conscience, I'm sorry to, just one more time, minute. Against my conscience was when I was asked by General David Tenyefunza to stand in as a surety for him. He said, okay, in that case, if I'm not coming as a lawyer, but as a surety, I will come. Then I came to stand surety for General. The chairman of the court said, surety number 1. That was the lawyer saying, look what yes. Then the chairman of the court looked at me and said, ask me, what rank are you? He said, but I'm a civilian, I'm a lawyer. Do you know you have come here to stand surety for a 4-star general? Do you have capacity, you, a civilian, to compare a 4-star general to return to court? Get out of my court. This time I didn't wait for arrest. I just disappeared very fast. So 2 more aspects here, briefly. Public interest litigation and the balancing act between politics and justice. I don't know. I don't have time. But this is again another interesting area. It is stated here, public interest litigation has been described as the expression of politics through other means. Because this route is often chosen when traditional channels of direct political action aimed at achieving social or political change, namely voting or legislative action, have been closed off or blocked. You will continue when I share this paper with you. This has, in effect, led to evolution of jargons like judicial politics, judicialization of politics, juristocracy. You will interest yourself in that. So public interest litigation has the potential to combine the virtues of political action with the legal processes. It can conscientize, mobilize people to legal blah blah. You'll read Professor Jugo. Then my conclusion is that judges should always be alive to the fact that the judiciary becomes a theater for political discourse when resolving explosive political matters. They should warn themselves of the dangers of castigating lawyers on what they call politicization of court matters. The gist of this is that courts become a theater of political debate, political discourse, and political fights. You can't shy away from that fact and say, don't bring politics to court. You find a judge You are handling a politically explosive matter and say, I don't want politics in my court, but you are dealing with the politics. For most people, there's a belief that judges are insulated from the wave and waft of that dirty game. No. The courts of law need to boldly and creatively devise a balancing mechanism in the stormy tides of politics and justice, bearing in mind the laudable observation of a celebrated scholar, standing between individual citizens and the wielders of power. The judiciary has become the ultimate and yet unwilling arbiter in the arena of democratic politics. They are standing between the citizens and those who wield the power. And essentially they become unwilling arbiters of democratic conflicts, political conflicts, and so on and so forth. So now the second last one is, I'll not delve so much on that. We have a problem, another challenge of the emasculated civil society. It is superfluous to state, and this is my belief, I don't intend to offend anyone. It is superfluous to state that a robust and aggressive civil society movement plays a pivotal role in public interest litigation. Public interest litigation is a new tool in the arena of civil society. It presents a strategic opportunity to engage the judiciary in ordinary societal issues and so on and so forth. It is regrettable to note that the civil society in Uganda is emasculated, debilitated, emaciated, malnourished, and almost decapitated. Those of you who belong to civil society, that is my judgment. You are emaciated, emasculated, malnourished, and almost decapitated. East Africa Law Society, Uganda Law Society, you are part of civil society. So it's up to you now to interpret my judgment. You are supposed to be vanguards of rule of law and everything, but the legal regime in the country regulating civil society, it's not meant to help you grow, to thrive, but to kill. The legal regime, that is the absurdity. Look at the laws, the NGO laws and what, they are meant to kill civil society, but not to. So if you want to test what I'm telling you, follow what happened to my brother Nicholas Opio. I've mentioned him there of chapter 4. He just got $300,000 US on his account, and that was enough to invite the wrath of the state. They are everywhere, every day. If you're a human rights activist, if you're a human rights defender, if you are like myself, 24/7 they are monitoring our accounts. And there is a threshold of what you are allowed to keep on the account. If you overshoot that threshold, then they will invite you to explain. So my brother Nicholas Opio, I think his account was always in red. All of a sudden they found there $300,000 US. I said, oh, you come and explain. So that is the nature of our world, public interest litigants, the risks we face. Misinterpretation, I think this is the last, misapplication of the sub judice rule. Lawyers and human rights defenders in public interest litigation have always been on the receiving end of the wrath of the bench. I don't want to elaborate this, I don't have time, for contempt of court and violation of the sub judice rule by discussing in the public domain matters before court. I strongly contend that the sub judice rule shouldn't be applicable in public interest litigation. In that particular case, the public is the litigant, and it would be ridiculous to stop a litigant from discussing the merits and demerits of their case. Get my point? Just one more minute, I'm sorry. I'm sorry. This is the only time I have you. You're not going to see me again. Public interest litigation, the client is the public. It's not the individuals before court. Now you are telling the public not to discuss their case, the merits and demerits, whether they should proceed with the case or withdraw it, and to also be informed about the progress of the case. And say, don't discuss it. It doesn't work out that way. I'll give you again my own experience. I was involved in a very explosive case, and immediately after court, Radio 1 invited me for Spectrum to go and discuss what had transpired in the court. I was, of course, not going so much into the merits of the case, but the politics surrounding the case and whatnot. Then all of a sudden, the then President Uganda Law Society calls in and say, he called in the talk show, live talk show. I'll not mention his name, is my friend. Said, what Yulukwago is doing is unprofessional. According to the rules regulating advocacy in this country, there were rules made during the Amin regime in 1978. Any advocate who appears before the public to discuss any matter must get authorization from Uganda Law Society. That's what the rules say. Who gave you mandate and license to go and debate these matters? So tomorrow, you will get the summons to appear before the law council and you answer for your conduct. Indeed, the notice came the following day. I now decided to drag himself personally to court in again another public interest litigation. He said, now I'm also filing a case against you for condemning me unheard, because you tried me on a radio talk show and convicted me that I was unprofessional. So anyway, we challenged the rules and the rest is history. But what I'm saying here, it doesn't make sense to apply sub judice rule in public interest litigation. Public interest litigation is not only the parties, this is what Oluka said. In public interest litigation, it's not only the parties immediately concerned with the petition who watch keenly for the gains and losses that may result from the court ruling. Such matters will invariably become the concern of the broader public, and so on, blah, blah, blah. Then finally, Karugaba says, public interest litigation attracts a lot of attention, and for this reason, it's often called publicity interest litigation. That it's called publicity interest litigation. Realization of the fruits, I will not talk about that. It's difficult because they are declaratory in nature, and the impunity prevailing in the country, it has caused the public despondence and disillusionment, because in most cases you get judgments in vain. So we must creatively explore ways of ensuring that in public interest litigation we enforce those judgments, not relying on the goodwill of the violators of the rights. Victimization of lawyers, I've said about that. I want some. You read Kanyehamba about, he defends, because when you are so much involved in public interest litigation, there are derogatory terms that are used against you. This is a controversial lawyer, a cantankerous lawyer. I don't know, there is now a new phrase they invented to describe Mabirizi. You know, Mabirizi had to spend 18 months in jail for being over litigious. In Britain, they had what they called the Vexatious Litigants Act. The Vexatious Litigation Act in Britain, they had it. If you file and file and file so many cases, they say, now you're a vexatious litigant. And they had sanctions imposed on vexatious litigants. So if Mabirizi lived in England, he would face the wrath of Vexatious Litigants Act. The very final one now, the other problem we are facing, rainbow lawyers. This is not my own creation. The word rainbow lawyers exists within our jurisprudence. Those of you who have search engines on your phone, you can check the meaning of the word rainbow lawyer. It is there. It's in the Black's Law Dictionary. It means a lawyer in Black's Law Dictionary. A lawyer, especially a litigator, who uses aggressive, unethical, or illegal tactics in representing a client, and who lacks courtesy and professionalism in dealing with other lawyers. With all due respect to my learned friends who represent the state in matters of public interest litigation, They invariably exhibit traits of rainbow lawyers towards public interest litigants or human rights defenders, blah, blah, blah. So every time I say state attorney, I say rainbow lawyer. I will say this with no puns intended, no intention whatsoever. I have my good friend, the Attorney General Chiwanuka Chiriowa. We went to class together. I was in the same law class with Chiwanuka Chiriowa. We used to sit at the same table at the law school. And at one time, he represented the counselors in KCCA who were impeaching me. He was the lead lawyer in prosecuting me before the Tribunal of Justice. And when I see him as the Attorney General, I don't want to mention the rainbow lawyers. May God bless you. I thank you.
Another round of applause for His Worship. Thank you so much, Your Worship, for that well thought, well researched, and well articulated paper. It was interesting right from the word go. Unfortunately, the time was not our best ally, but we enjoyed every bit of it. And ladies and gentlemen, I know we're quickly running out of time, but to continue on this discussion, please welcome Mr. Arthur Nsereko, the CEO of the Network for Public Interest Lawyers and a legal scholar from Makerere University, to come and give us techniques of how to manage safety, security, and risk for human rights defenders from these Rambo lawyers. I know most of us don't want to fall prey of what His Worship fell prey, being a convict of the court martial. So teach us how we can.
Members of the bar, all protocol observed. Take me to that slide of August 2016 and allow me to remind the Lord Mayor of these incidents. Somebody has my presentation somewhere. I'm a teacher by birth, training, earning, and calling, so I'm very time conscious. I will request you to bear with me. Next. 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 There. Back, 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 back. Just one more slide. 2016. We've seen these images. July 12, 2016, policemen, cane people lined along the streets to wait for FDC, former presidential candidate Kizza Besigye. July 12th. Next. July 25th. The hunter becomes the hunted when Makindye court summons the IGP then. The IGP then, Kale Kaihura. It wasn't an easy one because when the Directorate of Public Prosecution decides not to take action against these visible abuses and violations, public interest spirited lawyers decide to pursue private prosecution. And one magistrate is bold enough to issue criminal summons. May his soul rest in peace. Now, August 9th, 2016, the demonstrations began right in front of Parliament when the IGP and his 7 were meant to appear in court the following day. And then the following day, that was the drama at the courts. The Lord Mayor was one of the people, and I wonder why he's still talking about the security threats and risk. But in perspective, we've been talking about public interest litigation from the morning, and I have edited the other long phrase to say, when we talk of public interest litigation in perspective, it is impact litigation. We want to create broader change in society. We want to leave a lasting mark. Now, because you want to leave a lasting mark, the establishment is not going to sit back and allow you to leave that lasting mark. They will definitely respond. Robert talked about it in the morning. Senior lawyer, Honorable Andre Ogalo talked about it in the morning, that they will do what? They will fight back. So it is in the fighting back that issues of risk, security, and threat arise. Why are we interested in looking at risk assessment, security management? The duty bearer number one on issues, human rights, constitutionalism, rule of law, is the state. And the state has the power and the means to do what? To arrest, torture, harass, break in, and even kill. The moment you engage in public interest litigation. The Honorable Mama Mbabazi presidential petition, we had a break in to the offices of his lawyers. So, security is the freedom from intentional harm, but neither you nor myself can guarantee you that protection. It is the duty bearer to guarantee you that protection. And the duty bearer is government. While safety is the freedom from unintentional harm. Still, even here, I can't guarantee you that safety. You can't guarantee yourself that safety. It is only God. So what happens? The moment there is a risk, there is a threat. Because you're being a public interest lawyer, you are already a threat to the status quo, to the establishment. We shall return in equal or even magnified power. Hence, the need for us as public interest lawyers or strategic litigators to identify the threats, do a risk assessment, and then consider security management. It is those three things. So the issue of security management, identification of threats, and risk assessment is part of the strategy when we talk of strategic interest litigation. Remember, a threat is a declaration or indication with an intention to inflict damage. Now, this one I will narrate. During that attempted private prosecution of the IGP and his others, one of the police officers went around visiting the 15 lawyers that had indicated interest in pushing or prosecuting the private prosecution. He enters this lawyer's office and asks the lawyer, "Oh, what is your price? Mwagaraji." The lawyer says, "I want a better country." That police officer says, "I hope you know who you're dealing with." The lawyer says, "Yes, I know I'm dealing with the state." Threat. Threats can be direct, they can be indirect, they can be incidental. Direct if it happens to you directly, and we've seen this. The Lord Mayor has talked about my Mavirizi. That one has directly faced it. Indirect. One person is touched because they are in the realm of public interest litigation, the others do what? Retreat. If they can touch so and so, what about us? So we retreat. That is indirect. But there is also the Salumanya Narumanya, incidental. You are in the wrong place at the right time. That is also a threat. Case in point, I'm sure there were court clerks who had innocently walked into that marking the court on the 16th to do their usual work, only to find themselves in the same fracas with the lawyers that were attempting a private prosecution. So reflection when it comes to threats. Ladies and gentlemen, many people who make threats do not ultimately pose a threat, but they have made the threat. But also some people who make threats do ultimately pose the threat. And that's why we need to be alive. We don't take certain declarations lightly or all declarations lightly. But also some people who do not make threats ultimately pose a threat. So threat analysis, we need to scan the facts around the threat. You've received a phone call, not once, not twice, anonymous, hidden number. The tone, the language. You receive an SMS, and these things are not new. They are typical once you are in the trenches. So scan the threat, the surrounding of the threat. Step 2. Establish the pattern of the threat. These threats come in series. You receive a phone call here. Some people might trail you like it happened after that August 16th debacle at the court. Some of the lawyers who were at the court were actually escorted home. But because they had been heightened, their consciousness has been heightened. As they were driving home, their eyes were in the driving mirrors, and then they see these motorcycles escorting them home. They did not spend the night home. Sometimes some of the players are called in for questioning, and then something happens. We are now told the ministers are being invited by police. Come on, we talk. You invited one, you arrested. You invited the second one, you arrested. The third one. So as strategic interest lawyers, we need to be alive to patterns. Threat analysis. Brainstorm on the objective of the threat. Just like you also have an object pursuing strategic litigation, the perpetrator also has an objective in that threat. So put on the perpetrator's mind and ensure it is the most nasty of brains, lest you fall victim and yet you should have taken precaution. Step 4, contextualize the threat. And here in contextualizing the threat, allow me to take you straight to the force field analysis, where you identify and analyze the forces around you. Yes, you're going to court, but remember you're going against the perpetrator, who might be government. Government has all the state machinery, but you're also going to a court, which at sometimes plays state machinery. And then you think you will get justice as easy as that. So we need to do a forced field analysis and ask you, first of all, assess the current situation. Sometimes we say it may not be the proper time for you to go to court. Most of the human rights lawyers I talk to these days tell you it is not the current dispensation is not the right time, proper time for us to go to the civil division of the High Court to take our matters. Even somebody did raise it in the morning. The moment you go there, they will say Rule 7.2 of the rules says anything appeal without even listening to the merits. Define the objective, identify the driving forces, identify the restraining forces, evaluate the forces, and then come up with a plan. Risks vary according to your operating environment. They also vary in magnitude depending on the magnitude of the imposing impact. If you're bringing a pill case that is going to upset a certain status quo, beware the risk. The risk will come in equal force. So just like the perpetrator will sit back and think through your game, as litigators, we also need to sit back and think through our strategies to manage our security. Risks are not fixed. They change with change in operating environment. It was Robert Chirunda who told us here, today, if your case has political undertones, you don't have a constitutional question for interpretation. You go to the Constitutional Court and see whether your case will be cause listed or will be heard. The moment it has political undertones. But later on, maybe we should say, let it pass. So, risk assessment. 3 variables: threat, vulnerability, capacity. A threat is that declaration to harm. But we also need to be aware of those factors which make us prone victims to that threat. And there are so many. I will go back to August 2016. During the brief of the lawyers that were taking part in the case, we were even advised, stop eating everywhere except home. It comes to that. Why? When we went for the, so the magistrate gives grants criminal summons. With what protections or what support structures do you have around yourself in order to deal with your vulnerabilities and your threats? So to reduce the risk as a strategic interest actor, you need to reduce your vulnerabilities and your threats while maximizing your capacities. That's why in August, a team of almost 20 lawyers appeared before this single magistrate after the context had been well assessed and read. Sometimes security lies in the numbers. So risks vary according to threats, vulnerabilities, and capacities. Quickly to security management. So after you've appreciated that there is a threat and I'm at risk, which approaches are open to you? One, you can go for the acceptancy where you strategize to win over even the perpetrator. Let us negotiate. Okay, I'm willing to negotiate. Let us concede or consent to certain things. Or deterrency. You take measures to prevent unwanted access. And this is true even for your law firm. That the moment you start engaging, you've raised the red flag. We shall start watching what is happening with your business and the like. Or you can transfer or do the corrective approach where you leverage on the external strength and capacities of collective society. And this is where the East African Law Society comes in. The Lord Mayor ended by saying civil society is what? Malnourished, emaciated, The only thing he didn't say is it's castrated. And then he said, Uganda Law Society, you are civil society. And the truth is, in a place where all civic space is shrinking, there may come a time when there is no NGO dealing with issues, governance, human rights, accountability. History is going to do what? Is going to look on you bitterly as lawyers who have the tool of the law, who has the tool of public interest litigation, and who has the market of the court, but we've chosen to sit back. So, East African Law Society, we have an opportunity to fight for the civic space of the sub-region. The other time, we were going after the Tanzanians. Now they have some breathing space, and we are celebrating it. I don't know what the situation is like in Uganda, but Kenya, do not lie back. Tomorrow it will be you. So ELS, we have an opportunity for us to fight for that civic space, and the only way we're going to do it is through public interest litigation by transfer or collective approach. Very many questions we need to ask in drafting the security plan. Who or what are you trying to protect? Is it yourself? Is it your colleagues? Are they your staff? Is it family? Is it the community you're representing? Is it your assets? Is it your business? Answer those questions. Then what are the threats? What is the probability that that threat will actually materialize? What would the impact be if you did nothing about that threat? What would the impact be if that threat actually materialized? Then, how do I assess or understand these threats? All those are questions that we ask ourselves as we come up with a security management plan or response to a threat and risks. Then, what are the vulnerabilities related to this particular threat? It is always good for you to know your points of weakness, such that you devise the appropriate response. And then, what are the capacities related to the threats around you? For human rights defenders, sometimes some people are gracious enough to say when the threat is beyond, we can even flee you out of the country. Kakweza comes in point. Implement the security plan. What should I do to prevent? Now, these are standard operating principles or guidelines. What can you do in order to prevent this threat from actually materializing? How should I respond? Now, those are your capacities. If the threat is actually materialized. To a point of even telling people at home, even if it is my friend who comes knocking at my gate, I'm not present. I always walk in with the people that are meant to visit me. So nobody comes home saying he expects me. I should have come with you if I expect you. It comes to that point. Who will be involved in the entire plan? And this is where the synergies come through. It is not your own. You cannot win this. You cannot deal with these threats by yourself. So there are other parties that will be players. Think through all that. And then, if we're going to do this through networks or name it, we need to communicate the security plan to everybody that is involved. We need to even rehearse the security plan, draw different scenarios, and see whether that security plan will actually save your day. Enforce the security plan. If we have a plan in place, but people seem to be doing it otherwise. I will still go back to August 16th. August 16th, after an assessment had been done, risk assessment had been done, we were advised, do not drive your personal vehicles to that court. We shall have organized transport for all. And we shall use a vehicle that is not known to belong to any lawyer. Lo and behold, we get to court, and then there are lawyers that had come with their personal vehicles, and now the crowd outside has turned lethal. They need to access their vehicles, but then police is saying we have instructions to do what? To carry you out of this place. They had to return after 9 p.m. to pick their vehicles because they could not access their personal vehicles. The issue of enforced plan. And then they need to review these security plans each time you're going to engage on this matter. Having assessed the risk levels of that particular case that you are involved in. Thank you for listening.
Thank you so much, Arthur. Arthur's presentation sums up this segment on risk security and mitigation measures. I know I've seen a couple of hands. Many of you are burning with questions, but permit me, because of time, to go to the very last presentation of the day, and then we'll take a round of questions. So our last presentation of the day is on enforcement of court judgments in both domestic and regional courts. This presentation is by a very seasoned and well-respected senior advocate practicing in the region, and I know for a fact currently he's enforcing quite a couple of judgments, and he will be best suited to give us a presentation on the said topic. Ladies and gentlemen, let's put our hands together and welcome Mr. Justin Semuyaba.
Thank you. Welcome everybody, members. I respect protocol of all the big people who are here. I'm going to be quite fast because it seems we have lost time. My topic today is to talk about enforcement of court judgments in both domestic and regional courts. I think now, for purposes of today's theme, is for purposes of, I should put it in the perspective of public interest litigation judgments. Every one of you knows that when you get a judgment, it must be implemented, and in most cases, public interest litigation judgments are against the state. So, as our mayor, Honorable Lukwaga, said, facing the state is a nightmare. So, even now, when it comes to enforcement, you have the same challenges that you face when you are in the litigation are the same challenges that you will face when you are trying to enforce. Of course, as everybody knows, the challenges of in our country, things have changed a lot. May I remember when we had just started practicing. The most common litigations that we used to do in the law firm that I used to practice in was to go and get people who have been, kept incommunicado by security agencies. So the application of habeas corpus was a day-to-day routine in the law firm. Because every other time you would hear, so-and-so has been arrested, he has been kept here and there. But the good thing those days, and I'm talking about the 1990s, 90s, then early 2000s, you could get the habeas corpus order and you could comfortably go and take it to the IGP or the army commander, and the next day you have your person. But I doubt whether it's the same these days. I'm not so much into that area of people who are arrested because of recent. I think I've changed my area of practice. But when we were still there, for example, we had the Army Commander, General Mundu. He was so courteous. You could even enter his office and they say, you want, what do you want to do with him? The bodyguards, we want to serve him a court order. They clearly lead you to his office and you enter his office. And he diplomatically receives the order, even there and then gets the phone, he calls. And the next day you have the person. But these days, as everybody knows, the environment is so hostile. So, as somebody has said now, when it comes to how do you enforce the judgment, you have to be innovative. I would rather, my preparation so much concentrated on the enforcement of judgments from the East African Court of Justice. This is because when I was given the letter to make preparation, they mentioned that area. It's good to first of all know that the East African Court of Justice being created under the treaty, again the same treaty of the East African Community, Article 44, specifies that the partner states have, that execution can be carried out to enforce judgments of the court. Then the rules of procedure of the court, Rule 85, 1, 2, and 3, provide that judgments can be enforced in the various partner, in the courts of the various partner states, using the respective civil procedure rules that apply in those states. It's good also to address your mind to Article 38, which automatically puts an obligation on every partner states to automatically respect any court judgments and not to do any other action to escalate the dispute that has been resolved in court. There is also Article 126 of the treaty, which requires partner states to harmonize and encourage standardization of judgments within the East African community. Now, of course, the talk I always hear around with everybody who comments about the court. He says, you people go to that court, or you go to those international courts, but how do you enforce their judgments? Many people tend to think that there are no mechanisms for enforcement of these judgments. Incidentally, when you make an assessment, for example, the East African Court of Justice, which I'm much more familiar with, I can for a fact say that I think more than 80% of the judgments from there have been implemented. I will give examples. The first judgment I encountered was when we took the case of Sita Ndasebalu versus the Attorney General of Uganda. You can see that in our jurisprudence, mostly I see many judges quoting it on contempt of court. When we got a judgment against the Secretary General and the Attorney General of Uganda, and they were not implementing the judgment, we were innovative and filed an application for contempt of court. And I can assure you, with the contempt of, with everybody fearing to be adjudged contempt of court, they quickly implemented. So that clearly shows you that an application for contempt of court, I think even in our local jurisdiction, in case of public interest litigation, in case you see an order not being implemented, the moment you apply for contempt of court, everybody fears to go to prison. The moment you apply for a warrant of arrest, You can now see as we are talking how the big people are running left, right, and center. Contempt of court is a very, very fast method that can be used to threaten public officers who try to defy some of these orders. We have the case of Professor Nyang' Nyong and the Attorney General of Kenya. The Kenyan court was able to use the mechanism of mandamus, which mandamus we also have here in our judicial review rules, to force the treasury office accounts to pay the costs that were taxed in that case. So the prerogative of mandamus is also one of the methods that you can use to enforce even in ordinary public interest litigation matters. We have the case of Democratic Party, Mukasa Mbide and Attorney General of Uganda. After that case, the Parliament of Uganda was able to go and amend the rules, meaning that when the East African Court of Justice pronounced itself against the rules of procedure of the Parliament of Uganda that were not conforming to Article 50, Parliament quickly went and amended, and thereafter we got several other litigation, Anita Mong, Honorable Katuntu, challenging the elections of ELA members. So you can see that after the pronouncement of Mukasa Mbide case, the Parliament tried to reorganize the way they handle the election, meaning they became conscious of the fact that the other court judgments bind. So it's wrong for somebody to assume that when you go to that court and get a judgment, you'll completely get no enforcement. It's good also to address your mind to the fact that we have the reciprocal enforcement of judgment rules. They can at times also be called into action, because when you get a judgment in a foreign court, this time now I may move away from the East African Court of Justice and go to other regional courts. You can revisit your study in that area on the reciprocal enforcement of judgment. Any challenges in as regards as lack of reciprocal enforcement of judgments has of recent been sorted out by our courts here in Uganda, allowing the application of the common law principle of Committee of Nations. We have the famous case of Christopher Sells and others versus the Attorney General. Honorable Justice Elidad Mwangusha allowed enforcement of a judgment from the USA and applied what they call the common law principle of Committee of Nations. So, in case you find that Uganda doesn't have any reciprocal enforcement arrangement with a nation, a particular nation, you can quickly refer to that authority and invoke the Committee of Nation principle. The Committee of Nation principle has been applied in a regional court. As an example, the SADC court, the one that is for the South African countries. One time, there was a judgment, if you are familiar, if you still remember the time when the Zimbabwe state, by by force took over all the assets and land of the whites. So, forcefully or through some kind of legislation of compulsory acquisition, the white landowners quickly ran to the SADC court and filed a case that they were being compulsorily deprived of their land. This matter involved expropriation of farmers' land by the government of Zimbabwe. So they managed to get a judgment in their favor that internationally, just as you know here also, in our equivalent to Article 26, you cannot compulsorily acquire somebody's property without compensation. So based on that principle, they managed to get a judgment. Now, when it came to implementation of the compensation and costs aspect, they found it hard. No, actually they applied in the Zimbabwe High Court to enforce that order of compensation and cost. But they were unsuccessful because of the animosity of the Zimbabwe government. What they did is they were innovative and they went to the Constitutional Court of South Africa, another partner state of SADC. The Constitutional Court of South Africa applied the SADC treaty, which has similar provisions like the East African Court of Justice, that which state that execution of court judgments of the East African Court of Justice may be executed using the civil procedure rules of the partner states where the execution is going to take place. Now, what they did, they went and applied to attach the property of Zimbabwe in South Africa. They were successful because the Constitutional Court of South Africa, again, for the first time applied the principle I've just been talking about for Committee of Nations. They also emphasized the principle that since the treaty doesn't specify in the treaty provision that the name of the country in which execution will take place, so it leaves the leeway to the party to look for any assets in any partner state where the execution will take place, and then that party can apply using the procedure rule of that partner state to carry out the execution. So you can see that the Constitutional Court of South Africa, partner state SADC, was able to attach assets of another partner state, Zimbabwe, in order to enforce a monetary judgment by the regional court. So anybody who thinks that the regional courts don't have mechanisms for execution should revisit his thinking and try to read around some of these things and see that it's possible. You can see that of recent Uganda alone is paying Congo millions of dollars because of an ICJ judge. Actually, to me, it would seem that international judgments are enforced faster than local judgments because the country finds itself in a situation where it has obligations to observe international legal principles. Whenever you try to raise an issue that they have failed to enforce, they quickly run around and try to do something. So it's a wrong fallacy for some people to think that regional court judges The Treaty of East Africa as well has Article 104 of the treaty, which guarantees freedom of movement of persons, labor, and services. This has been enhanced by the enactment of the Common Market Protocol to govern trade relations. As I've said before, you look at Article 8, Article 33, 1 and 2 of the treaty. You look at Article 5, you look at Article 126. Actually, those articles, when you read them carefully, you find that the judgments of the East African Court of Justice take precedence over judgments of the National Court. So the moment you have extracted decrees or orders, the National Court just has to accept that judgment. As far as now, the most recent case, which can be an example of, enforcement of treaty obligation. Those of you who have been following the Court of Appeal, we have had of recent this case of testimony model. Some representatives of numerous car importers used car vehicles sued the Uganda Revenue Authority, the Commissioner of Customs. At first, in the High Court, issues arose about the application of because I think the contest was the valuation of goods and services under the East African Community Customs Management Act number 5, 2005. That act is made under the East African Community. So, the judgment, first of all, Justice Madrama, when they were still in the commercial court, emphasized the fact that there is need for, within the East African region, to have harmonized interpretation of the treaty and any acts of protocols made thereafter. So he emphasized that there should be a uniform application or implementation of that act, the East African Community Customs and Management Act, because it applies to all the East African Community partner states. Now, President, you have seen those who are following precedents from the Court of Appeal, that actually the Court of Appeal has, I think, upheld the High Court judgment and ordered URA, the Commission of Customs Management, to follow the principles properly of valuation of goods or whatever. Specifically, I think this time they were talking about used vehicles. But it seems like the act would apply to all kinds of goods. So you can now see that a treaty obligation is being implemented by a national court. And probably that judgment will even be borrowed or used by other lawyers in other partner states about the valuation of imported goods. People who import high value goods, I think, will be the first to take benefit of this, because there has been a lot of unfair valuation of such goods, and high taxes are attracted. But the court has said it was contrary to the act. That's the kind of enforcement we are looking at within the East African region. There's a case, Katavazi versus Attorney General of Uganda. I think Honorable Rubago, you mentioned about some instances that we've had in our judiciary over time. They have been coming growing and changing. So the Katabazi issue, when you say Katabazi case versus that region, it came out of the instance of the attack on the court, on the High Court. The lawyers by then took the case to the East African Court of Justice, and the East African Court of Justice condemned that incident and ordered the government to compensate Katabazi. But I know as a fact that even if the incident was nasty, the government was able to implement that award, and they paid, whatever the cost that the lawyers involved knowing. But I think that is for the first time when they implement, they apply the prerogative of mandamus, and the Attorney General complied. I think that can be as far as the East African Court of Justice is concerned, but I cannot stop without mentioning that Article 38 of the ESCJ Treaty enjoins the partner states, the Council of Ministers, to take all necessary measures required to implement the judgments without delay. In case a litigant finds he has got a judgment and they have failed to implement that judgment, he can file another reference for contempt or failure to implement that article. That is actually what the City and Several case is about. Now, the rules of procedure, as far as the institution are concerned, Rule 74 requires party who has got a judgment there to apply for an execution order and fill in a Form 9 a form applying for execution. That form is actually almost similar to the one that we have in the civil procedure rules, where you mentioned the kind of order you want to implement. Then the registrar will be able to issue an execution order, which you can now transfer to wherever you want the execution to take place. So, anybody studying the execution principles processes in that court must be able to read carefully the schedule of the rules of the East African Court of Justice. Now, of recent, the East African Court of Justice, the jurisprudence has grown to an extent that it's now handle or entertain not only matters to do with rights or obligations, but with the enactment of the Common Market Protocol, some businessmen have started seriously going there to file their cases. Because the Common Market Protocol is an extended jurisdiction of that court. Recently, the partner states signed protocol to extend the jurisdiction of the court to include trade and investment related matters. So the court now is open for even business. So that would mean that necessarily the judgments that we are going to be getting from there in the future involve money judgments. So you can see that now money judgments are increasing. This was achieved when we successfully argued for Honorable Margaret. Why? You remember when she was being, when she had been illegally impeached by the EALA members. We argued her case. If you chance to go and read it, when we won the case in the first instance division, the court had ruled that their role is only interpret the treaty and just make declaration. We sat down and said, no, how can we stop there? How can we come and win a case and not make revenue, and not get any revenue? Because we are asking for her to be paid her salaries, which salary areas, damages and all that. So we appealed to the appellate division and we managed to get them to set a precedent that the East African Court of Justice, just like any other court or international court, is not only there for purposes of hearing judgments, hearing cases, and just give academic judgment. The court went ahead and looked within the treaty and found out that the treaty enjoined the court to handle cases to do with the application, with the interpretation, and hearing to the treaty. So in that they were able to come to the conclusion that a winning party in a court case is entitled to get remedies. That is when now the court has started to give. You can see that now judgments are coming out where you are able to get special damages, general damages, and get compensatory or exemplary damages, or monetary judgments, some sort. So the jurisprudence of that court has now grown. So that means enforcement mechanisms have to be strengthened. The binding nature of the judgment on the partner state is well embedded, well stated in the treaty. The other mechanism that some people use, because these partner states have got committees where they normally meet. They have sectoral council committees, they have council of ministers, they have the summit. What the court does, whenever judgments are passed, they make a report of what judgments have been passed. So when the council of ministers or the summit, when the presidents are meeting, they bring them forward and put them on the agenda. And then they arrange that matters where each partner state is told, you have to address this issue. You have to address you lost the case here, try to address this issue. So that kind of mechanism of raising these issues within the council of ministers meeting or summit is, I think, the same mechanism that the African Court of Human and People's Rights uses when the court has passed judgment against any country which is a member of the African Union. The judgment is transmitted to the headquarters at Addis Ababa, and when the AU meetings are taking place, these judgments are brought up in the meeting, and the concerned countries are told to implement. It works because it is brought to their attention, and because in terms of international community, these countries become shy when issues are raised internationally. So that's also another way, diplomatic way of trying to ensure that we get judged. I've talked about the Foreign Judgments Enforcement Act rules that can be applied. Now, back to the topic here, and maybe Lord Mayor, you have more experience there in public interest litigation here. How do you enforce the public interest litigation here? After all, the public interest litigation arises out of court situation. So we lawyers, we are supposed to be innovative. You've had a judgment for a client who has been pulled out of those areas where they are arrested and brutally, whatever, tortured. So the next thing is now enforcement of the judgment. Now enforcement of the judgments in the regional courts and even here, because they are judgments against the state, you all know how long it takes to get, for example, an award of damages or compensation tax here in Uganda. But we have the restrictions that no execution can be carried out against government property. But in my view, and I've seen some good Kenyan judgments interpreting that area. They have said you can resort to judicial review remedies and invoke the principle of mandamus. And I've seen a judgment in Kenya. Again, I think Professor Nyang' Nyong'o. If you look for Professor Nyang' Nyong'o judgment on mandamus, you'll find that to an extent the Kenyan courts have come to actually say, and I'm sure even here it applies. Judicial review proceedings are not civil proceedings. So they have said that if the Government Proceedings Act is telling you that you cannot execute judgment, doesn't mean they shouldn't comply with the judicial review enforcement mechanism. So mandamus is largely a very available mechanism to force officers who have refused to comply with court orders. When you get a mandamus order, of course you must have the intention or next to apply for contempt of court. That if that officer has refused again to comply, you must be able to apply for contempt of court. Now, the Kenyan lawyers have very, very cleverly devised that kind of way of executing those judgments, arguing that it's not execution, it is trying to force a public officer to do his duty. When you read the definition of mandamus, it's not execution, it is an enforcement. So people in public interest litigation shouldn't sit back and say, I've got the judgment, but what can I do? There are mechanisms which can be applied. And I can assure you, even these public officers fear prison. Now, as we talk now, you can see how the whole of cabinet is. I'm sure they're sleeping under their beds. Or boys go. I had someone hid in a wardrobe. Imagine a minister. So when you get these orders, don't fear. I think we shouldn't fear. You get the order, you say, officer so and so, you are required in court. They are also human beings. They fear. And I don't know, me in my experience, watching, you see some of these events take place, but you keep on watching. The people who fear prison most are the ones who have the power in their hands. Police officers, I can assure you, they like to arrest people, but when you tell a police officer that you are needed at police, and I'm serious, where is Navakova? Why doesn't she report to police? Navakova, you remember her, but she hasn't reported to police. They also fear. So when you get these orders, warrant of arrest, we shouldn't, I think, over too much say that they are human beings like everybody. So enforcement also can carefully and tactfully and very comfortably be done using innovative methods. The innovative method is judicial review prerogatives coupled with contempt of court. Anybody who is told that you have defied a judge and you tell him the judge has summoned you, come and go and tell him why you are not complying with the court order. They will comply. So, ladies and gentlemen, let me conclude by saying that most of these public interest litigation or the litigation in regional courts are litigations against the state. But certainly the mechanisms for enforcement of the orders that are got from those courts are there. We just need to train, to have much more of these trainings, exchange experiences, and exchange what is done elsewhere in other countries, and find a way of enforcement, having very good enforcement mechanism, which actually are within the law. Of recent, I've seen, and I've not seen lawyers challenging. I saw a letter from the Attorney General, and it keeps on saturating on our legal forums. Somebody is now changing some of these things like garnishi. The Attorney General writes and say, police officers, such and such things are not supposed to be done. When you go and read the law, it's completely, totally different. The garnishi has never been abolished. Mandamus prerogative orders are still in the statute books. But now you find a legal opinion being saturated around, which creates an impression that completely you can't. Me, I think ever since I've been in practice, I've managed to pick awards from the Attorney General and Finance by using those mandamus mechanisms. So somebody to get an impression that because it is a state, you can't execute is completely wrong. More than 80% of the court judgments from the East African Court of Justice have been implemented by the partner states. Thank you.
Thank you so much, Senior Semiaba. We greatly appreciate your informative presentation. The Lord Mayor has requested to take leave. He has another engagement somewhere far away. But colleagues, we've also come to the end of our session today. And we would like to thank you so much for bearing with us and for staying with us for this long. And we are greatly appreciative. We shall share copies of the presentations of today and a report of the events that transpired today on your personal mails, and you'll be able to keep track. So, without any further ado, yes, I've been requested that those who may want to join the Lord Mayor for a photo can come take a photo with the Mayor, and we shall disperse at leisure. Thank you so much. Mr. Munabi, this is your opportunity. Your Worship, Mr. Munabi wants to move in your footsteps and probably become a Lord Mayor one day. Thank you so much. Please feel free to grab a cup of coffee on your way out, and rest assured we'll share the presentations. Thank you.